in the court, you have to serve them. You'll find their information in the in the records. The documents that you should have received should also have their information.
I will do that, ma'am. I will forward it to them as well, and I'll forward it to the office, your office.
All righty. Thank you. Okay, you all excused at this time. Thank you, Mr. Pippin.
Oh, thank you, Judge. I have a couple more. I'll hang tight.
Oh,
Thank you.
okay. All right. So the next one I have is Daniel Stanton versus Georgia Farm Bureau. Hold on just a second. Hold on.
Hey, Glenn.
Hey, Dallas. Good to meet you, sort of in person, Dallas.
No, I feel like this has been around a while, but we've never gotten the chance to meet.
No, you took over during COVID.
Yeah.
Is Lee still at the firm, or is he gone?
He went to another firm,
Oh.
and so I inherited a bunch of stuff like this.
Uh-oh. All right, sorry about that. Okay, so Stanton versus Georgia Farm Bureau 2023 CV 00434. So who's here on behalf of Stanton?
Glenn Lowenthal here on behalf of the plaintiff, Daniel Staten. Good afternoon, Your Honor.
Sorry.
That's okay. This is on our motion for partial summary judgment. And I'm estimating maybe 10 minutes of your time, and unless you want us to rehash the briefs, but otherwise,
no
need to do that.
No.
Well, I wasn't sure we were here for that motion. I thought we were here for a status conference, and we were trying to talk to the clerk about, we thought we were on a jury calendar for a trial. So I apologize. I didn't realize that's what we were doing today.
No, this morning I had pretrial conferences for the August 26th trial calendar. But this afternoon I have civil non-jury bench trials. So we're hearing motions, and we're resolving contract issues.
Oh, okay.
Dallas, when at the last meeting, you guys had a conflict.
Yeah, I was at trial in
yeah, so we didn't know if that was going to go. So that was when this motion was originally scheduled to be heard, and then the court just said, we'll try and squeeze you in on the next available calendar that we can.
I apologize. That was not, I did not realize that. I am probably not the right person for this then. Let me see. Okay.
Who would the right person be?
The associate who wrote the brief on that, but he's not in here. So, hold on. Okay, let me see. I apologize. Let me.
Is the associate that wrote the brief is she still with your firm?
So, the Park Burford is the one who worked on this one in the end. The one that initially started it is no longer here, but Park is here. He's just not in here right now. Let me find this. I'm sorry.
You're a good lawyer. You can argue it.
Well. Let me see if I can find. I'm not finding that brief. Oh gosh. I am sorry. I'm not prepared to argue it if that's what we need to do today. And that's my fault. My calendar had it at a status conference for a non-jury trial.
Are you okay if court decides it just on the briefs?
I can get it to pull up. I can try to make a call on that.
Because what I might suggest, I was going to bring up another logistically, defense just filed a motion recently for partial summary judgment on the bad faith issue,
Yes.
the answer of which is not due yet.
No.
The ruling on this, on our motion, affects that motion. If Your Honor granted our motion for partial summary judgment, in my opinion, and Dallas, I would think you would probably agree, that kind of moots the point of that motion, of the defense motion on the bad faith claim. If the judge said, as a matter of law, there's no defense for a motive, then that would mean that there's a case to bring for a jury on the bad faith. So I was going to suggest, regardless, since that ruling could affect it, if she rules against us and finds that the case should go forward on the contract claim, then once we have her ruling, I give me 10 days to file a response to that ruling. I mean, to file a response to your motion. That way I don't have to prepare a bunch of stuff on the motive issue, since that's what we're arguing now.
Sure. I don't have, so I don't think, I think my client would really prefer that we argue these. I went and pulled my other notice too, and I don't see on there, I really do apologize. I don't see on there anything about this hearing. And I know because I was in trial, I wasn't here the last time, and that's what it was for. So I apologize on not being prepared to argue that, but I don't know that I would, my client would be very happy if I said we can just waive arguments. Is there any way we can get on the next calendar to argue it?
I mean, in some situations, I would want to say yes, but my clients have been patiently waiting for over 5 years now since the fire. This motion was filed in November. We had to wait until April to get it scheduled. And then because of your conflict, we couldn't go, and then had to wait 3 more months to get it rescheduled here at the end of July.
Well, looking at the
I think it's, I don't want to wait another 3 months to make something for argument. And I don't know if you're going to have a conflict with the next date.
So you said that the gentleman who wrote the brief is not in here. It's virtual. Can he be in here?
Not, I don't think, I mean, this week he's out of the office on vacation, and granted, I can see if I wrote it arguing on the fly, I'm hesitant to do that to an associate. I also, in looking, the notice says 0 continuances on contract. I don't see any indication. I really do apologize, and that's my fault for not knowing that that's what this calendar was to be.
Well, if it was a pretrial calendar, it doesn't sound like y'all are close to a consolidated pretrial order. So
No, we had called earlier this week asking why we were on a non-jury trial calendar, because the matter was, a jury was requested to hear the matter.
right.
And I believe the individual my assistant spoke with said we had to appear to make sure the court knew at this hearing that it was supposed to be on a jury trial.
I'm clear, but like Mr. Lowenthal said, we were trying to give you all the opportunity to have a hearing on outstanding motions. If I can decide a partial summary judgment, then that lessens what I have to try greatly, and it puts y'all in a different posture when it comes to settlement. So I don't care what we call it. I
Sure.
put you where you fit in so that the court can hear what needs to be heard. I just so happens that on Wednesdays, it is easier for me to do civil things, So generally I will do non-jury bench trial calendars. I'll stick motions on there. I'll do pretrial conferences. So we had pretrial conferences in the morning, and now we have the calendar, which is sort of an omnibus calendar where we can hear these things. But yeah,
Can
I'm
we
not.
be heard next Wednesday?
Well, as it stands, we have other stuff on that calendar. Give me a minute. Yeah. Hold on a second.
We're in trial, judge, criminal jury.
That's
We don't have-
right.
we're in
Yeah.
trial.
Yeah, next Wednesday's a no-go because that is our first criminal jury trial after our break. So yeah. It's partial summary judgment, is it something that you, I mean, like, is something that you can't what's Mr. Lowenthal, because I've looked at a bunch of stuff today. I'm looking at my notes, and I know that there's a breach of contract and a bad faith claim, but essentially, give me the gist of your partial summary judgment motion.
The gist of it is in fire cases, after the plaintiff has proven just basically the contract exists, it's, everything's been paid for. When the insurance company wants to put up a defense of arson, there's three, the case law is clear. And it's cited in the briefs. There's three things they got to prove, intentionally set fire, no unexplained circumstances, and motive by the person that set the fire. So our motion is that there is a lack of evidence as a matter of law on the issue of motive.
And
that
one of the
defeats their
defenses.
defense.
Mhm.
Yeah. And if one prong of the three-legged stool fails, then the whole stool falls over and the defense is defeated.
Okay, and y'all are arguing so you don't want to give up summary judgment, as I have a new staff attorney, and so she's getting her feet wet on on some of these things. And so I've told her, I said, yeah, I only have to really hear two things. I have to summary judgment motions and JNOVs. And so I am clear that if the parties request a summary judgment hearing, that I need to have it, but I'm giving you the hearing and y'all aren't ready. Even though the motion's been filed, a written response has been filed. So presumably, having filed a written response, there's somebody in your organization who should be able to argue it, especially since it speaks to the three prongs of the breach of contract and bad faith issues that were presented as part of the defense.
So
and Your Honor, we were the ones that requested oral argument. Due to the circumstances, I'm willing to waive it just because I want to get the case moving forward one way or the other.
I get it.
So I would request that the court, one, since the notice didn't say that's what this motion or this date was for, I again apologize. I'd request that the court give us a date that they would let us argue it. If the court is inclined not to do that and tell me that's not an option, then I would have to stand by the brief that's filed. However, given that we do believe that our case is valid as far as the motives and the issues and the questions of fact created, I mean, subject to our pending motion, I would think we'd want to argue all of it. But if I have to stand by the brief that's filed, I will do so if the court.
Okay. Yeah, because I always believe, as a former staff attorney myself for Superior Court, I always believe that if you don't put it in the brief, then you abandon it anyway. So I'm not sure what more oral argument does for me. Y'all seem to like it, but not sure how much more it helps me in any way in making this decision. So the court's going to review the briefs again on the partial summary judgment motion. The defendant's partial motion for summary judgment is not yet ripe, but I would just say go ahead and respond to it in the time that is necessary. And if my decision is dispositive or changes the profile of the case in any way, then you've at least done your due diligence with respect to the response.
Okay.
Is it okay if, that's why I was asking initially, rather than respond in the time allowed, can I get a continuance to respond until after your ruling on our motion? I could do it quickly. I mean, a week. Or do you want it now so that you can maybe rule on both? Well, they're going to want oral argument on that motion too, I'm assuming. So
I want it now, because even though my decision on your motion may change the profile of the case, my thought process is that defendant's motion is not dependent upon the decision in your motion or dependent upon what you've written. So they're two separate motions. Respond to them in the timely fashion, and then if I need to set oral argument for the second one, I'll do that. But yeah, go ahead and respond. And so just FYI, Wednesday's my civil day. It may not say what you think it should say. If you have any issues, email Ms. Val or email my staff attorney and say, hey, we asked for a jury trial. Well, you got outstanding motions and we're going to hear those. And so we'll let you know. But yeah, Wednesdays are my civil days, and I get in what I can fit in an effort to make sure that folk who want a hearing can get a hearing. So.
Okay.
All righty. All right.
Okay,
So
I'll
I'll expect to hear the response to the defendant's motion, and also or see the response to the defendant's motion, and also we'll get an order out on the plaintiff's motion.
Okay.
Judge,
And I agree with Your Honor about briefs. Sometimes oral arguments don't add anything. And I usually just request them as a matter of course, just because a lot of times the judges on these technical fire cases want to hear something or have questions. And if you don't have any questions, then there's nothing really much that I'm going to add that's not in the brief.
Yeah, it's our opportunity if we're confused or, we don't know what's going on, for us to ask questions and y'all to educate us. I'm clear on the purpose, but yeah, the test is pretty clear. It's a 3-pronged test. And so if there is any issue of genuine, material facts still outstanding, then we move forward to trial. If not, then we move forward with SJ.
Okay.
Thank you.
All right. Thank you.
All right. Thank you, Judge.
You're welcome. All right. So next is American Express Nation versus Anna Lesbia Wyatt and Iglesia de Cristo. Anyone here on behalf of American Express? All right. And Ms. Val, have we heard anything from the plaintiffs on this? Or Ms. Powell?
no, ma'am.
Okay. And anything on behalf of Anna Lesbia Wyatt or Iglesia de Cristo?
I haven't heard from any judge, plaintiff or defendant side.
Okay. One second. All right, so in this case, for the case has been called to trial on the civil non-jury bench trial. The plaintiffs, neither the plaintiffs nor the defendants appeared. At this time, the case will be dismissed with prejudice for want of prosecution. All righty. Next case is Adon Royale versus Malika Agaba.
Yes, Your Honor. I'm Adonis Royal.
All right, so Mr. Royale, you're appearing pro se. Miss Malika Agaba, Mr. Alonzo Nelson is in the courtroom on behalf of Miss Agaba. And so, sir, you are suing for fraud. At this time, sir, I'm going to ask you to go ahead and tell me what is the basis of your suit for fraud.
Okay, so for the IRS debt, that's the biggest debt that I'm trying to tackle. I
Okay,
had got
let's-
IRS to open investigation.
Slow down for me. How do you know the defendant in this case?
Oh, the defendant is my mother.
Okay, all right, that makes it a little bit clearer. And you are suing because
She admitted to opening a business in my name, like using my social security number in order to collect the funds. She admitted to it on email, and I attached those documents. And I was trying to get it appeared to the IRS as if I was in a different like tax bracket, as if I received so much income, but it was never me. And because she never paid the taxes on it, they have this outstanding debt on my account that I'm trying to get cleared up. And I have the email and text messages of her.
how much is the debt?
Oh, the IRS debt now it's daily accruing, but the debt is over $20,000 now.
Okay.
They compound interest.
When did you become aware that there was a business that purported to be in your name?
In 2017, when I was stationed in Korea.
Ooh. And what part of the military were you in?
The Army.
Okay. All right, and at that time, what did you do when you found out that there was a business that purported to be owned by you?
Okay, I reached out to my mother. It was other things that appeared first. It was like rims and other things started appearing on my credit, and people started contacting me. And I started doing the research, trying to see what else is possibly in my name. And that's when I found out when my tax refund didn't come on time, and I contacted the IRS. I say, "Hey, where that?" They say and they sent me the transcript stating how much money that they was trying to say that I was collecting every month and how the total came up to what it was. And I explained that I had never had a business, and they gave me the address of the business, and that's how I knew it was my mother.
So when you say the IRS, did you mean like a PPP loan that they were giving out during the pandemic, or was it something else? Because you're saying the IRS is saying you collected a lot of money.
Okay, it wasn't from the PPP or SBA. It was from her. She had an actual shop on Highway 85 in Riverdale. Okay. And in order to collect the funds, she opened up a Square account, a Stripe account, in order to receive the funds.
So I think she was receiving funds through the business. So the business was operating, and taxes were not being paid on the purchases made and the income from the business. Okay.
Correct.
What type of business was it?
A clothing boutique. With like a woman clothing boutique with like purses and clothes.
Okay. All right. And did you at any point file something with your, with any of the credit bureaus to indicate that you had an issue, with someone using your identity?
Yes, with all three credit bureaus, the Federal Trade Commission, Square, and Stripe, since those are two appended agencies that be collecting people funds. I wasn't sure which one it was, so I filed a report with both of those. And I also, once I returned from Korea, I couldn't do a police report over there, but once I returned from Korea, I was stationed in Missouri, and I filed a police report in Missouri about it as well.
Okay, and I don't think of anything else. So credit bureaus, trade commission, police report. All right. All right. Is there anything else you want to tell me?
In addition, recently I just repaired one of my old phones. I also have voice recordings as well too, that stating that she did it and she would like to fix it.
Okay, and how much are you seeking? You're alleging that you were damaged in because of the fraud. How much are you seeking because of that?
I'm seeking $30,000, Your Honor. The IRS debt, even though it was only $20,000 something in total, in addition to that debt, the progressive leasing that was on my name, the BB&T Bank, all the different things that was on my name, causing me to pay so much money to this current day in interest, because every single time I apply for somebody, I either have to put a larger chunk down than average, or I have to pay over 20% APR. So that's why I'm trying to sue for $33,638.42. And the Navy Federal credit card as well, which I attached that I paid it off. And I also attached a letter of her saying she used my Navy Federal account when I went to basic training for the Army, and I got the amounts listed on that as well. It was a credit card, and it was also a savings account.
And how much was that?
The letter. So the $474.08 was for the savings account. $240 was for the credit card. And
was this part of the $33,000? Or was this separate from the 33,000, or is part of it?
That's included in the 33,000, Your Honor. Okay. I'll just give you a breakdown.
Okay, that's fine. You mentioned Navy credit, and I just wanted to make sure that that wasn't a separate request.
Understood.
Okay. All right. Is there anything else that you want to tell me?
Just that Georgia Power,
Yes.
I moved back to Georgia in order to be able to get this case started, because I filed reports in Missouri and Vegas, and it seemed like I wasn't getting no progress. It seemed like the police would not pursue. Okay. So I moved to Georgia for 1 year to fix this.
Yes.
And when I moved to Georgia, I found out that somebody had open lights in my name for the amount of $274.20. So I had to file a fraud packet with Georgia Power. Once I reached out to Georgia Power gave me the address. I have screenshots as well from my actual Georgia Power portal. And it stated the address that my mother stayed at before, which was 7144 George's Way in Morrow, Georgia, 30260. So I had to pay that in order to have lights at my new residence in Georgia while I was pursuing this case.
Okay. All right.
So that's all you want.
Thank you. Mr. Nelson, anything on behalf of Ms. Agaba?
Oh, Judge, I'd like to ask Mr. Adonis Royale some questions about his claim. You're asking the court, you said, can you hear me?
Yes, sir, I can hear you.
You're asking the court for $33,000, correct?
Yes.
And in your complaint, you said you were asking for $10,000 for defamation of your character.
Yes.
When did that supposedly occur?
So the defamation occurred with all of the fraudulent activities in my name, and in addition to that,
Go ahead.
the defamation occurred. I have as well. I'm giving you those times. July 15th, 2022, July 15th, 2022, and approximately July 23rd as well, in which she told her sister, my cousin, and her mother that I was trying to kill her and her mother.
Well, you make no mention of any of those things in your complaint. Your complaint strictly about money that you claim she caused you to have to spend. Is that not so?
No, correct. But defamation is the act of damaging the good reputation of somebody.
Yes.
And that's included when a person fraudulently get things your name to make it hard for you and then make you look irresponsible and then make you charge higher rates. So that's still included up under defamation.
So let's go back. You said the IRS claim arose back. You learned about that in 2017.
Correct.
And that was at the time, from the time you filed the complaint, that was 6 years before, correct?
Correct.
And that would have been part of what you're claiming defamed.
Yes, that's a part of that. Yes.
And then you said that the George's Way document, when was that? When was service provided? I believe your document shows that service was provided in 2016.
Yes, for that address from 8/9/16 to 11/10/16.
And did you live at George's Way in 2016?
In 2016, temporarily, yes, but I was homeless, so my mother allowed me to stay there for a little bit of time.
And did your mother live there with you?
Yes, it was her house.
Okay, and you used the power that was provided at that location?
Yes.
So, and you didn't pay any bills for that power at that location, correct?
Say that one more time, sir.
You didn't pay the Georgia Power bills at the George's Way location,
Correct.
but you lived there.
Temporarily, when I was homeless, I was staying with my mother. But
And
yes,
when when Georgia Power contacted you, you filed an affidavit that said that you didn't live at that address, or you didn't open that account, correct?
no, I let them know that I did not give anybody permission to open service at that address. And I let them know what was my address, my last current Georgia address, which was 235 Roberts Drive, apartment 5G in Riverdale, Georgia.
And you didn't pay that bill to Georgia Power, correct?
I did pay the bill in Georgia Power, as I told you, Your Honor.
Any proof that you paid that bill?
I do. I have the screenshots right here from the portal, and it explains when did they first tell me, and I also have proof of them actually saying where did it come from, which was that 7144.
Now let's but that's the affidavit that you attached to your complaint is dated 2022, correct?
Yes, the affidavit to Georgia Power.
Yes.
Correct.
And you were living at, I suppose, at Westlake Avenue at that time?
Correct.
And when did you pay the Georgia Power bill?
Okay, so as soon as I moved into that address, I could pull up the screenshots for you to see. As soon as I moved to that address, I had to pay it. I paid it in increments. Initially, I had to pay a $65 fee in order to move in. I had to pay $30 additional fee to move in, and after that, Georgia Power let me know that I had a previous balance, and they attached it onto that. So I have the proof of all my payments for that year.
And that started in 2020. When did you move to Westlake?
That started in 2022.
Okay.
I can give you a definite date if you would like.
Well,
Georgia Power will back it.
I would very much like a definite date, but I can come back in a minute.
Well, let's get the definite date. I don't like to come back. That's chewing my cabbage twice.
All right, Judge. What was the date that you paid the Georgia Power bill?
Okay, no problem.
Mr. Royale, we're having some issues technically. Can you check your audio and see if we can do a little bit better? You still there? You there, Mr. Royale? Okay, now you're muted. Sometimes when you touch the icon for the little old-fashioned microphone, sometimes when you do that, there's a little upside down arrow. When you click on that, it'll give you the opportunity, you're screen sharing now, but the arrow will give you opportunity to change your audio channels so we make it better hearing, better reception. Okay, so I don't need you screen sharing right now. Check your audio. So go ahead and stop screen share. There you go. All right, can you say something for me? Mr. Royale? So when you see the little old-fashioned microphone, what you doing? So are you using a computer or a telephone? If you're using a computer, give me a thumbs up. Okay. So where at the bottom of the computer screen, you should, when you move your cursor, if you exit full view, at the bottom of your computer screen, you should see something that looks like an old-fashioned microphone. And right next to it is an upside down is an arrow pointing up. Click on that. When you click on that, then it'll allow you to test your audio. Okay, so it'll say select a microphone. But you want computer audio. So if you go down on the list and it says microphone array, select a speaker, test speaker and microphone. Under that should be computer audio. Okay. All right. Okay, still can't hear you. I was hearing you better before. So the other option is you can log on from your phone, but one of your devices has to be muted or else we'll get feedback. I still can't hear you. You can do the same log on from your phone. Ask for computer audio. You there, sir? Okay, did you turn your phone on? Did you join by phone? Okay, you keep showing me, but I can't see because of the glare on the, oh gosh, you got like 3 phones? Okay. I can't see what your phone is saying, but I can't see it because all it shows up is like a white screen. It's just light. You can send a chat. You can chat to me what's going on and I'll read it out loud. Okay, all else fails. Is there a teenager somewhere near you? Mr. Nelson, that's the best tech support I've ever heard of. So, I mean, yeah, it's funny, but it works.
Well, I've been-
Somebody in their 20s, 19, 18, 16, any of the teens.
Does the court wish to stop and give him an opportunity to finish and follow the rest of the calendar, or do we need to?
Yeah, thank you, Mr. Nelson. Let's hold on. We'll pause this hearing and let me see if I can get another one in while he's doing tech. He's trying to figure out his tech. All right, so ladies and gentlemen, for those of you that aren't currently talking to me, please mute your devices because you may think it's quiet where you are, but I'm hearing background noise and that usually comes when there's open mics. So I'm going to ask that you mute. Okay, so while we're waiting to get Mr. Royale back, and if we can't get him back, we'll continue to the point to when he can be present in court and we can have an in-court hearing. But Velocity Instruments versus Anastasia Barnes.
Joe Pippin for plaintiff, Your Honor. Thank you.
All right. So Mr. Pippin is present on behalf of the plaintiff. Is there anyone here on behalf of Anastasia Barnes?
I'm back, Your Honor. I'm back, Your Honor. I'm back, Your Honor. I'm back, Your Honor. I'm back.
Okay, so Mr. Royale, it's going to be a lot of feedback. So you have, I guess, how many devices do you have on?
Just one now. This is the only one I'm on now.
Okay, great. That's better. All right, hold on just a second. I'm going to mute you. All right, so Mr. Pippin is here on behalf of Velocity Instruments. Anastasia Barnes. Last call for anyone on behalf of the defendant, Anastasia Barnes. So we're here for the motion for summary judgment. Because what was missing on the motion for summary judgment was the fact that was the proof that the plaintiff was the party in interest,
Yes,
guess
ma'am.
due to an assignment.
Yes, Your Honor. I believe that has been I believe the amended one has been filed. Let me see. Has the court received that documentation yet, Your Honor? I guess was that. So I'm
Ms.
looking to
Powell,
see.
you have the amended one? Ms. Powell, you're muted. I think you're talking, but you're muted.
Oh, yes, Your Honor. I'm just double checking.
Okay.
I'm going to pull it up right now. So the most recent summary judgment we got from plaintiff looks like it was in January.
Okay. Does it include an amended assignment or an assignment?
No, the summary judgment was denied, and there has not been.
All right, so Mr. Pippin, I don't have anything since to prove that there was that your client was a party in interest due to an assignment or some other conveyance.
Okay, and Your Honor, I'm not sure why that hasn't been filed yet. I defer to Your Honor if the court would be inclined to please give us one opportunity to get that filed. I'm not sure why the amended one hasn't been received yet. I'm just going off of my documents here, and I thought that the motion for summary judgment was in order.
Yeah, if you haven't gotten, if you have filed it and it's just that we haven't gotten it and it's some glitch, that's fine. If not, file it immediately.
Yes,
And
ma'am.
then I'll make a decision.
Yes, ma'am. And if it is denied, plaintiff's ready for trial. Certainly understood, Your Honor.
All right, thank you. Did you have
Thank
anything else on this calendar? I see another
Yes.
Velocity Investments.
Yes, that's position 7 and 8. Yes, Your Honor.
Okay. I see a 7, I don't see an 8.
I believe
Oh,
that
7 and 8 on the 2 p.m.
Crown versus Whitney. Yes, ma'am.
Okay, all right, 8 on the 2. All right, so Velocity Investments versus Gary White.
I'm
Gary?
here, Your Honor.
All right, so Mr. White, may I see you, please? All right, sir. Sir, you're gonna have to sit down because if you move and you're gonna make me dizzy. So here, this is a matter 2023 CV 01528 for breach of contract. And the plaintiff is seeking damages. The motion for summary judgment was denied again for a failure of a conveyance or an assignment.
Yeah, okay. Same announcement as the last one, Your Honor. I thought the amended one had been filed already. Apparently that's just all we're lacking is the showing the assignment of the contract, and I apologize for that.
All right, Mr. White, the plaintiffs have filed what we call a summary judgment motion, stating that they filed the complaint. The answer that they received and that was filed from you does not present a defense that would keep them from going forward and prevailing on this case, meaning they've established that there was a debt owed, there was a contract, that there was a debt owed, the debt was not satisfied, and that you have not given them any other defense that would make up for debt being owed. So is there anything that you wanted to say to address the pending summary judgment motion?
I'm not even actually sure who Velocity Investments is, so I'm a little confused. Are they the original creditor? I've never heard of them.
Probably not, because they haven't presented an assignment, which is going to make it which is going to be part of how I decide this case. But since you are here and you're entitled to be heard, so generally what happens in these cases is whoever has the original debt will sell the debt or assign it to someone else for collection. So this debt may have been assigned. I have no proof of that at this time, but that will have a bearing on how I decide the case. But because y'all are here, if you have anything else that you need to present that the court should consider, then I'll give you that opportunity.
No, like I don't even know who the creditor is for me to really speak on the accuracy. It seems like that amount.
Did you look at the summary judgment? I mean, did you look at the complaint that you were served with?
It was a while ago, but offhand, I can't. I'm looking at this name, like I have the paperwork that I still have. I have moved a couple times, but I don't know like amounts to say. I'm not saying I haven't had an unsecured loan before, but I don't know who I'm really facing, if that makes any sense. I can't say if they're accurate. It looks like whoever it is looking for the max amount of interest, because I've never got a loan and didn't pay, but I owned a business, and when I lost everything, I got sick twice. I just couldn't keep up with them, but I can't say the accuracy of anything to this because I don't know who it is. If you sell a debt, I know it was an unsecured loan if it was one, but I made payments on any loan that I had. I probably didn't finish paying it because I couldn't at the time, but I can't say. It looks like it's for how much is it? $5,000?
No, I'm sorry to interrupt, Your Honor.
ahead,
It's
sir.
Prosper Funding LLC is the original account holder, and I understand the court needs this information. We'll get that filed. But Prosper Funding LLC, with the unsecured loan dated February 2nd of 2021. Payments would have started in March of 21. It was a $9,500 loan.
Yeah. So I know if if that's the case, I made payments. I don't know how much was what went towards what,
Okay.
or that imbalance to what they're asking for as opposed to that. I'm not trying to say I don't owe them any money or anything like that. I just didn't know that that's who it was, and I don't know the accuracy of the amount they're asking for.
Okay, well, if you want to locate the paperwork that you were served with, or if you want to come down to the clerk's office and get a copy of the paperwork you were served with, the case number is 2023 CV 01528, and it would be in the state court clerk's office in Clayton
Yeah.
County.
Okay.
And y'all may want to talk about that pending my decision on the summary judgment motion, okay?
Okay.
Thank you, Your Honor. And I would definitely, obviously not giving legal advice, but strongly encourage Mr. White to reach out to the firm on the papers you were served, sir, and they could answer your questions more fully and perhaps work out some kind of agreement we could get filed with the court.
Okay.
Judge, if I could make an announcement on this case and the preceding case.
Miss Powell, it's a little hard to hear you. Can you get closer to?
Is this better?
Yeah, that's much better. Thank you.
Okay, if I can make an announcement on this case and the preceding case, at the time of the initial motion for summary judgment and separate documents, the plaintiff did prove the assignment. There was not an amended motion, but plaintiff did prove.
All right, so thank you. So Mr. Like I said, Mr. White, first thing, not giving advice, but for anybody on the call, if you are served with paperwork by a marshal, a sheriff, a process server, please very carefully look it over, because it is important. If somebody's going to send someone to serve you with legal papers, it's important that you look it over. And if you're having, problems understanding it, take it to somebody who can help you walk through it, because it does make a difference when you get to this point and the court has to make a decision about a judgment, against you, that's going to require payment. That, we understand that things are hard and it is difficult times, but though that's not the basis for us to not do a judgment in favor of the plaintiff. So I get that, but it's important that you understand the paperwork that you're served with and what your options are. Okay.
Understood.
All right. So I'll be making a decision in that case. And Mr. White, if you want to communicate with Mr. Pippin and the attorneys in the case, that's fine. But I'll be making a decision, and both of you will get a copy of the order.
Perfect. Thank you.
All right. And let me just get back to Mr. Nelson and Mr. Royale. Mr. White, you're free to go at this time if you choose to. Mr. Royale, because I think we got his audio back. Mr. Royale, if you'll unmute for me.
Yes, Your Honor.
All right, and Mr. Nelson was in the middle of questioning you, and where we left off was for the Georgia Power. You all were discussing the date that you established your own Georgia Power account in 2022 versus the 2016 Georgia Power account.
Yes, Your Honor. 9/19/2022 was when I opened up a service for 541 Westlake Avenue. And I have the portal in which that's when they told me that I owed a past due balance of $299.20 from Georgia Power from 7144 George's Way. So I started paying on that. 11/2, my first payment was $123.95. My second payment was $95 on 11/14. And then also as well on 12/2/2022, I paid the remainder balance, which was actually my light bill, which was $204.29 at the time. So that's what current.
Mr. Nelson.
Now, fraud again. And is it your testimony? Am I correct in saying that in no instance any of the
Okay, Mr. Nelson, I'm losing you. Deputy, can you troubleshoot the audio for me?
Oops, I'm sorry.
Speak again for me.
Can you hear us?
That's much better. Okay, whatever you're doing, that's much better.
I think it's good.
All right, Mr. Nelson, go ahead. Mr. Royale, unmute to answer, but I think there's some background noise in your area. Okay, go ahead.
It looks like he's muted. Oh, you said to answer. Mr. Royale, did Ms. Agaba ever represent to you anything about the Georgia Power account? Did she ever make any representations to you about the Georgia Power account?
No.
Did she make any representations to you about the IRS?
Yes, I provided that with the court when I filed this on there.
And was that representation made to you prior to your learning that this account was outstanding?
Say that one more time.
Did Ms. Agaba represent to you in any way any information about the IRS account before 2017?
No.
And did she represent to you in any way any information about opening a Square account?
Yes.
And did she do that before 2016?
No.
So is it true then that you didn't rely on anything that Ms. Agaba told you in relation to any of these accounts prior to her opening them or anything of that kind?
Say that one more time.
Ms. Agaba, is it true then that Ms. Agaba never made any representations to you about the accounts before opening them or exercising control over whatever she was doing with them?
Correct. She never told me anything about them. She just went and did them on her own.
And you've testified that you learned about the IRS account in 2017.
Yes, correct.
And have you paid the IRS?
No.
So
They take theirs up front. So every tax return, they take some off. They take some off.
So you have not paid the IRS the money?
Correct.
Well, now that wasn't his response, Mr. Nelson. He said every tax return, they take some out. So in effect, if that was his money, then, and they're taking it out, he has paid. What, do you know what they've been taking out, Mr. Royale?
No, Your Honor. I can log to my portal in which it'll show me like some of the payments that they take out, and it don't go back that far. And then what I can pull up, the reason why the balance is so high, because they say I'm still paying the interest because the balance is so high. So that's why it looked like the total isn't coming down. That's how the lady explained it to me yesterday.
Okay, but have you in any way figured out how much money of what you are entitled to as a refund that they're taking out to service this debt?
No, Your Honor. I don't have the exact total.
Okay, do you have a payment plan with the IRS that you're gonna service this debt over time?
No, Your Honor. I opened up investigation with the Taxpayer Advocate Service, and once I opened up the investigation, once I gave them documentation, they told me that I need to pursue this in court. And then they say after I get out pursuing this to court, basically email all the paperwork into Fresno, California, their office, and then they say they will go for there once they see that I'm actually actively pursuing it, despite me giving them the police report and things like that. They want to actually see I'm serious about it. And then they say it should be for me to get everything that they have took from me.
But let me ask you this. So they have made some representation somewhere that some of what they've retained of a tax return is used for this debt?
Oh, yes, they're big on that. Anytime they're supposed to give me anything, I get a notification to say, hey, go to your outstanding debt. And they say when everything's said and done, once I'm cleared, they say everything will be refunded to me when that happens.
Okay, but have they given you an amount of what they've taken out to date? You said that
No.
they tell you that you're just paying you're servicing the interest on the debt, but have they told you how much that is?
No, Your Honor.
Okay. All right, go ahead, Mr. Nelson.
And it was, I'm just trying to make sure I have all of the accounts covered, Judge. Your Navy Federal account was in 2013 when your mother used the account, is that?
Correct. It's dated and timed by my mother on the paperwork I provided to the court.
And your BB&T account, the $844, that was in 2013 as well, was it not?
Correct.
So what did you
Mute for me, Mr. Royale. Okay.
when did you go to South Korea?
2017.
And when did you come back to the US?
2018.
And you've been in the US since that time?
Correct.
And when did you leave the military?
2/28/20 honorably discharged. 2/28/20.
Okay, so you've been out of the military 3 years before you filed this complaint.
Since I served the court paperwork, not since I filed an initial complaint. My initial complaint was with the police department once I returned from Korea, with the Missouri Police Department, then the Las Vegas Police Department, then the Georgia Police Department.
And when did you file the first police department report?
In 2018, once I got back from Korea.
Have you paid BB&T?
No, I have not.
And you said you paid the $240.
Who are you referring to? Navy Federal?
Yeah, you said you paid that $240.
Yes, the credit card. Yes, correct.
And do you still have that account?
I don't have access to my Navy Federal account due to the rest of the outstanding balance.
Did you receive any benefit from any of the money that you claim your mother
You said, did I receive any benefit from any of the money that she did?
that you claim she fraudulently got in your name?
I haven't got any benefit from any of the money that she admitted she fraudulently claimed.
None whatsoever.
What'd you say, sir?
I said no benefit whatsoever.
Correct.
That's all I have for him now, Judge.
All right.
Judge, can I ask you a question?
Sure. I may not be able to answer, but you can ask.
Okay. When I first received the notification, they let me know that I should urge to drop my case due to the statute of limitations. The initial argument I thought I would be having with them would be, they were trying to say statute of limitations, but now they're not saying it anymore. So I'm kind of confused. From my understanding, the way the statute of limitation work is that when it's something like IRS, it don't go away. It's not something that expires and fall off your credit or nothing like that, unlike different debts. So since the defendant had actually admitted to, and I have all the paperwork and voice audios as well, why can't we just that's black and white right there. That's her email, that's her address, that's her work address. I got the audios. Why can't we just wrap this up? Let's not prolong this.
Mr. Nelson?
The statute of limitations defense is still in play. He has admitted actually that he had knowledge of all of these supposed fraudulent transactions from at least 2017. Obviously, his documents show that the Navy Federal account was 2013. His testimony is that the Navy Federal account was 2013. The BB&T account was 2013. He claims he's paid the Georgia Power account, but that was 2016. The fact that the IRS debt is outstanding does not address the issue of his fraud claim as it relates to when and if Ms. Agaba perpetrated a fraud against him. And I would submit to the court that his testimony that she never made any representations to him would constitute a defense to any claim of fraud, and that Mr. Royale cannot show that he relied on anything that Ms. Agaba told him that would rise to give him a claim for fraud. So I would submit that we can wrap this up with the judgment in favor of the defendant, because he has not made out a claim that or presented any evidence that supports that she perpetrated a fraud against him. If she made representations.
So using his credit, his social security number, his name, his information to establish credit without first getting his consent, that's not fraudulent?
It's not a fraud that would give him a rise to a cause of action, Your Honor. He would be, and possibly if he files a lawsuit, or if Georgia Power had filed a lawsuit, or if BB&T had filed a lawsuit of some kind, they would be the ones that the representations were made to. You can't perpetrate a fraud against a person unless you have made representations to that person on which that person has relied. So he does not have a claim for fraud based on Ms. Agaba, what he's claiming that Ms. Agaba did. That claim would lie with the creditors or other people who may have lost money or other things. But
he's paid those debts on behalf of the accounts taken out by her. He's had to pay because she took out those accounts. And so he should at least have a cause of action for reclaiming money that she caused him to owe.
Judge, he claims that he has paid. And if you look at the timeline, I would submit to the court that the statute of limitations that run even on those claims. So if he
he was an active service member. Is there any relief for him under the Service Member Civil Relief Act? Because if you're away serving the country and somebody uses your information to perpetrate, to establish fraudulent accounts, and whether he relied on her saying something or not, the accounts are undeniably fraudulent because somebody relied on her information to establish these accounts and to use them and to use his credit. So he was in the service of the country at the time, and there should be some form of protection under the Service Members Civil Relief Act to keep him from having to come back to destroyed credit and mounting debts.
He was not deployed outside of the country, and he was in the country from 2018 forward, Judge.
He was out of the country from 2017 to 2018, and he's argued here today it was 2017 when he discovered that his credit was being fraudulently used.
And when he came back into the country in 2018, if you want to give him relief under the Sailors and Soldiers Relief Act, his statute would have still began to run at that point in time. He would not have been just because he's active military does not give him, you don't have to do anything ever. When he was deployed in Korea, that may be the only period.
So the ongoing debt with the IRS so what you're saying is that because he waited until he got back into the country to file police reports and to pursue this cause of action, that his mother gets away with basically stripping him of his credit and money because he he was away in the military and he reacted in the way that he knew, the only way he knew to react when he got back.
Your Honor, I submit to you that he is not entitled to recover. He has testified that he has not paid the IRS debt, so he is.
But no, that's not what he said, Mr. Nelson, and we're not going to continue to say that he's not paying. If they're taking money out of his returns, he's paying. If they're sending him information and he's paying even incrementally, he's paying, and the debt still hangs over his head. So you want the court to say, well, you know, he hasn't incurred any damage because he's not paying, and because, you know, he waited too late to address something because he was overseas while she did it. But he has an active IRS debt that with interest mounting that she caused. And he also didn't agree to have any of this happen to him. But you're saying that because he's making payments or they're taking the money for him periodically, that he's not entitled to any recovery?
I am saying that he's not entitled to recover on a claim of fraud because, Your Honor, she made no representations to him, number one.
Well, he is entitled to recover on a claim of defamation.
Well, he's not entitled to recover on that because there's a 1-year statute of limitations on defamation claims. And that statute of limitations starts to run even if he doesn't know that the claim is out there. So that long expired as well. So he has no claim on defamation because it's been, what, at least 6 years before he filed the claim, that he would have known about the claims arising. But even if he did not know about the claim, the statute still starts to run from the time that the claim would have arisen to begin with. So there's no defamation claim. There's a statute of limitations issue there as well, Judge. And so
so the fact is, I'm horrified, but you're arguing that there's nothing I can do for the fact that his mother totally stripped him financially.
Judge, I don't think there's anything any relief you can grant him on any of these claims due to the expiration of the statutes of limitations on all of these claims. And unless and until, I mean, I don't know how to address the IRS claim from the standpoint of whether or not he has to pay it or whether or not he does.
Well, he's already given testimony that he's paying it. They're taking it.
But he hasn't given us any testimony as to what he has paid, first of all. And giving him, you can't give him a judgment for the entire amount because he hasn't paid the entire amount. And again, we are talking about something that was 6 years. Fraud claims usually have a 4-year statute of limitations.
Clear.
So when he got here in 2018, if you exclude the 2017 period when he was out of the country, when he got back in 2018, somebody, if he was going to file a lawsuit, he should have filed it before 2022. He didn't file this one until 2023. So his statute had expired before he filed anything. And again, he has not shown that he relied on any representation from his mother to him that caused him to suffer any kind of fraudulent damage or damage from her alleged fraud is what I should say. So I think he has failed on all counts. The statute of limitations clearly has expired on all of these claims.
There are some days when I really don't like the limitations on my power. But one limitation I don't have is I get to say what I want, as old people and judges get to do. And since I'm old and a judge, Mrs. Agaba, you're a horrible person to defraud and take from your son in this way, and then to leave him with the debt without paying it, even though you've acknowledged you did what you did. Horrible. Just horrible. as a mother, I don't countenance people coddling kids and raising people who can't stand on their own 2 feet. But obviously, Mr. Royale is very astute and has been able to determine what was done to him and has gone about it in the best way he knew how to address what was done to him. But that does not erase the fact that you are a horrible, horrible person. And just, I just can't even say enough about how you can defraud your own flesh and blood and then sit there smirking and clear in the notion that you've gotten away with it because he was away serving his country and he reacted in the best way he knew how when he got back. If you had any heart and any morality, you would pay back the debt that you caused. And I'm going to study the information that Mr. Royale has provided. And before I make a decision, this is the Georgia it requires that there be notice pleading, but it doesn't have to be pinpoint and specific except with respect to fraud. And so if there's any other claim upon which he can prevail in this case, I think I've heard enough for him to prevail. So yeah, we'll be fly specking that. Mr. Nelson has done a good job in representing you. And I'm sure he had to hold his nose to do it because what you did was horrible. All right. All right. So Mr. Royale, you'll get an order from the court. It may not be to your liking, but it may be what you need to establish the pursuit of these actions and to assist you with addressing it with the IRS and any of the other creditors. Okay. And Mr. Royale, I'm quite impressed. Most of the time, you know, if somebody's pro se, they are not as prepared as you will have been. And so you might want to consider going to law school, Mr. Royale.
Thank you, Your Honor. Thank you. My wife was actually looking into law school, so even when I was in the military, she helped me with my cases. And
well, then she needs to go. I mean, it's never too late. Trust me.
Thank you, Your Honor. And I don't know if you can. I don't even know if I can use them or not, but I have actual voice recorded conversations that we done had.
Yeah, the only reason that those don't help is because of the statute of limitations. And so I'm sure you have them, but that might help you with the criminal matters. It not so much with the civil, but you can present to the police or to, because it's IRS involved, maybe federal authorities, what information you have. And so that may result in something with respect to a criminal investigation.
Understood. Thank you, Your Honor.
All right. Thank you. Long time no see, Mr. Nelson. Thank you so much for your appearance, sir.
Thank you, Your Honor.
All right. You're free to go at this time. I'll get you an order out.
So I can log off?
Yes, sir.
Okay. Thank you, Your Honor.
You're welcome. All right, next on the calendar. LVNV Funding LLC versus Jennifer Bird. Anyone here on behalf of LVNV Funding LLC? Anyone here on behalf of Jennifer Bird? Case 2023CV01108. The motion for summary judgment.
Judge.
Yes.
A consent order was filed last night.
Okay, thank you.
So,
all right, so
Kiara will get that to you.
All right, thank you. And on the 2 p.m. civil calendar, JP Morgan Chase versus Jackson, Barbara Jackson. Anyone here on behalf of JP Morgan Chase Bank 2023 CV02472? Oh, consent I'm sorry. I think there's a consent order in that one also. American Express versus Tanaka Carr and Ulari LLC.
Good morning, good afternoon, Your Honor. Madge Buckle on behalf of American Express.
Hi, Ms. Buckle. How are you?
I'm good, Your Honor.
All right, and anyone here on behalf of Tanaka Carr? I see a Tanaka on the screen. Is that you, Ms. Carr?
Yes, it's Tanika. I'm here.
Tanika, okay, may I, could you, bring your video up for me?
Yeah.
All right, so look on your screen. If you touch your screen, the icons should come up. If the icons come up, then you're looking for something that looks like an old-fashioned microphone, and click on that. Otherwise, when you touch your screen, right next to your name, you should see a blue box with 3 white dots in it. Touch on the 3 white dots in that blue box. It should do a pull-down menu that allows you to start video. I'm sorry, on the icon should look like an old-fashioned video camera. But if you click on either one of those, it should bring up your video. Okay, there you are. All right, so Ms. Buckle, on behalf of American Express, it is a breach of contracts case. Do you have, I believe, a witness to testify as to damages?
I do, Your Honor. However, before I do that, we sued both Ms. Carr and her business.
Okay.
So
Is there
I
an attorney here on behalf of Laurie LLC?
No,
So Ms. Carr, do you have an attorney representing your business?
no.
So in state court, as a court of record, it's required that if you have a corporation, that the corporation requires that there be an attorney to represent them, such that they can protect the fiduciary interest of any shareholders or any other parties involved in the corporation. But you can represent yourself. So at this time, Ulari LLC is unrepresented, and a default is proper.
So I called to try to get a continuance because I did indicate that I wanted to get counsel, but I was unable to secure at this time. But when I asked, the lady that I spoke to on the phone said that there was going to be no continuance granted. So,
well, ma'am, the breach of contract case was filed in September of 2023. You filed your answer in October of 2023. And so you had plenty of time if counsel was what you wanted to have appear on your behalf. When we get cases, I get cases continually. And so I may get 30 of these cases filed in a day. I can't, once they're filed, they go into the track of, there's discovery that's being done, the parties are talking, but once it gets to the hearing date, or the trial date, everybody's going to want a continuance. You've had plenty of time if you were going to engage the services of an attorney prior to today's date.
okay, I did make an attempt to contact them to talk about the debt, but every time I attempted to talk to them, the only thing that they wanted me to do was confirm that and acknowledge the debt and figure out how, like I was trying to figure out where it came from because I'm unaware. This is not something that I created. So
okay,
I wasn't really sure what else to do from there.
So generally, these debts are liquidated damages, but they have brought somebody. So liquidated means that there's a contract and you know specifically what amounts weren't paid. And there's a specific number. And when they file the case, the number's already known. Generally, when that happens, they'll have an affidavit. Those are liquidated damages. They don't generally have to prove those separately. But today, Ms. Buckle has brought a representative from American Express who can testify as to what is owed. And so once that representative has presented the information, then you have the right as the defendant in this case to ask him any questions that you might have, and also to make a statement on your behalf or present any argument to the court. So you'll have that opportunity. As the plaintiff, they go first because they have to prove their case and they have a burden to prove that case. Okay.
Okay.
All right. So Ms. Buckle, you can go forward.
Thank you, Your Honor. Your Honor, just a small opening before I do go forward. Your Honor, this is a personal loan, and business loan. Miss Carr was a personal guarantor to this debt. And she actually took out two loans in May of 2022 and July of 2022. She did American Express did deposit it in her account. She did make some payments until she stopped. The total balance that we're asking for that she owes is $31,785.85. We're asking for court costs of $364.05 for a total of $32,150.90. And my witness will testify accordingly, Your Honor.
All right. Mr. Hamilton, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do, Your Honor.
All right, Mr. Hamilton. Ms. Buckle, your witness.
Thanks, Your Honor. Could you please state your full name for the court?
Yes, good afternoon. My name is Sean, spelled S-E-A-N, Patrick Hamilton.
And where were you employed?
I'm an assistant custodian of records for American Express.
And how long have you been employed by American Express?
28 years.
And what is your current position?
Assistant custodian of records.
Can you explain what you do in that position to the court?
Yes, as the assistant custodian of records, I have a unique user ID and password that gives me access to all of the written documents housed by American Express as they relate to our credit card and loan businesses. That includes card member agreements, loan agreements, the information provided through the application process. As well, I have a working knowledge of how the types of accounts are issued, the loans are issued, and the manner in which we process applications for those types of loans.
So you are familiar with, personally familiar with American Express records?
I am.
And you're familiar with the way American Express keep its records?
Yes, I am.
Okay. And those records are kept in the ordinary course of American Express's business?
Yes, they are.
Okay. The records that I'll be showing you today, those entries are posted at or near the time when they incurred?
Yes, they are.
Okay. And you have personally reviewed these accounts today, before now, right?
Yes, I have.
Okay, I want Exhibit P1. Your Honor, we did file Exhibit P1 with the court.
That's fine.
That's the first I'm trying to share, Your Honor.
If you want to share screen, that's fine too. Just click on the, pull it up on your computer first and then click on the green button, the green icon.
Okay. Thanks, Your Honor. Let me put that up and then go back to this. Okay. I can share. Okay, can you see that, Your Honor?
I can.
That's okay. This is the first time I'm doing that, so excuse me, Your Honor.
That's okay.
Okay, I'm showing you what is marked Exhibit P1.
Yes, I see it.
Okay, that's the first page.
Yes.
Can you tell the court the date on that document?
Yes, this was dated May 22nd, 2022 at 3:13 p.m. Eastern time. This is the loan agreement and personal guarantee document for what is known as cabbage funding, also known as blueprint lending. And you can see on the left-hand side under the borrower information, it says the borrower is Ulari LLC.
Mhm.
with an address at 3136 Ridge Circle in Rex, Georgia. And the business representative and guarantor is Tanika Carr. On the right-hand side, it shows that the lender is American Express National Bank.
Okay, and how much amount, what's the disbursement amount that was given to her?
Yes, we lent her an amount of $18,200 with a 12-month term to make monthly installments. And if she did make those installments, the total repayment amount would have been $19,292, which includes the loan fees and finance charges.
Okay. Let me go to. Okay, let's go to loan purpose. Can you explain that to the court?
Yes, it says you and the business representative represent and warn that the loan will be used solely for business purposes, and it is indicated in your application, and not for consumer, personal, family, or household purposes. You and the business representative represent and warn that you will not use the loan to fund dividends or distributions to your shareholders, partners, members, or other owners of an equity interest in your business. This loan is not a consumer transaction as defined in the UCC.
Okay. Business representative number 3, can you explain that to the court?
Yes, it says you, which is Tanika Carr, as the business representative, understand and agree that you're entering into this loan agreement on behalf of the borrower, and you are executing a personal guarantee. In your individual capacity, business representative personally and unconditionally guarantees the performance of all the covenants of borrower in this loan agreement, including but not limited to the borrower contractual covenants herein and borrower's payment obligations herein.
Okay. Going down here, explain she promised to pay to the court.
Yes, it says you promise to pay the disbursement amount shown above, plus cost as defined below, plus all other amounts that may become due under this loan agreement. The total minimum monthly payment and payment due date, as such terms are defined below, are shown on each monthly statement that we send you. You must pay each total minimum monthly payment by the payment due date, even if you do not receive a monthly statement. You may not apply any credits you have or any American Express accounts or on any account you have with any American Express affiliate to your loan balance.
Okay. With the advent of default, she defaulted on the payments, right?
Yes, unfortunately, she did not pay this balance in full.
Okay. Did she sign this account?
These loans are all filled out online. Everything is done electronically. When you apply for an account, American Express utilizes several pieces of data that are presented in the application, including her personal information, social security number, telephone number, IP address, and even the bank account that they're asking us to deposit the money into. We verify with national databases that the information links back to not only the individual, but the company.
Okay.
Pardon me one second.
And this document that you just testified to the court, these are American Express records pertaining to this defendant, right?
That's correct. And if you see on the page that you're showing where her name is printed, Tanika Carr, and the date May 22nd, 2022 at 3:13 p.m., that is her electronic signature.
Okay.
So what happens when they make an application, we review everything, and if the information that we received appears to be legitimate, then we send the physical copy of this to the defendant to review. And if they choose to accept the terms and conditions and want us to fund the loan, then they have to sign it electronically, which this was done.
And this is our first loan from American Express, that's correct?
Yes. Yeah, so the blueprint loans or the cabbage loans, we establish a line of credit, and then the borrower can tell us how much of that line of credit they wish to utilize. So if we gave her a $50,000 line of credit and she only wanted to borrow $30,000, she could borrow $30,000. But if 2 months later she wanted to borrow another 10 or another 20, that would be available to her as long as this loan was still in good standing.
Mhm. Your Honor, I would like to tender Exhibit P1 into evidence.
Ms. Carr, any objection to P1 being admitted into the record of the court?
P1 is the paper?
It's what she has just presented and has been testified to on the screen.
Well, I don't want to admit it. I never signed that.
Okay, no, it's not you admitting to the veracity or truthfulness of the document. It is whether you are in a opposition to the court considering it as an exhibit and it being admitted into the court's record. Two separate things.
Okay, yeah, I don't want to admit it into the court's record to be considered because I didn't do it.
Okay. The basis of the document, there's nothing objectionable that I can find to it, and you haven't raised an issue. I get that you don't agree with what the document says, but that doesn't mean that it is not authentic. But if you wish to have an additional foundation laid, that she has laid the foundation that allows the court to accept the document because it was a document kept in the normal course of business by American Express. Okay, so over your objections, the court is going to admit plaintiff's exhibit number 1. Okay, but to be clear that when it's time for you to ask questions of this witness, you may also refer to this document and the contents of the document. Okay.
Okay.
All right, you may continue, Ms. Buckle.
Okay, I'm gonna introduce Exhibit P2.
Okay.
Mr. Hamilton, can you explain to the court what that is?
Yes, like I said earlier, we issue a line of credit, and then the individual and the company can request up to 8 draws against that line of credit. So the first loan was issued in May of 22, and a second request for funding was done on July 1st of 2022. At that time, we issued a loan amount of $25,500 to be paid in 18 months over time with a total repayment of $27,795. The $22,995 is the loan fees and the interest if you take the full 18 months to pay it off.
Okay, and just to your attention up here, is the same address?
Yes, 3136 Rex Ridge Circle in Rex, Georgia. The business representative and guarantor is Tanika Carr. The name of the company is Ulari LLC.
And which bank did American Express distribute the money into?
Navy Federal Credit Union.
And American Express distributed the money to this bank on both loans, right?
That is correct.
Okay. Does this agreement basically say the same thing that the first agreement says?
It does.
It does?
Yes.
And this agreement, our American Express document pertaining to this defendant, right?
That is correct.
Your Honor, put into evidence Exhibit P2.
All right, Ms. Carr, same thing. Do you have any objection to this this document being admitted into the court's record? You can also use it if you wish to upon your opportunity to cross-examine the witness.
Okay.
Okay, it will be admitted without objection.
Okay, Your Honor, I am going to.
I'm sorry?
even if I object, the last time I objected, it still went in anyway, so I don't
Yep,
think.
I can admit it over your objection because you're objecting as to the contents of the document and whether they're truthful. The document is being admitted because the plaintiff has presented the document as a business record kept in the normal course of business by American Express. Now, if you have something that shows that their business record is incorrect, you have more than an ample opportunity to present that. However, the way it works procedurally, and which is why it's always, it might have been helpful for you to consult an attorney, is because there are procedural rules that the court can follow, and evidentiary rules that the court can follow, that if you haven't been trained in those rules, it's going to be difficult for you to understand. If you have some objection to the content or the truthfulness and you have evidence to counteract what's presented, then by all means, when you have the opportunity to speak or to examine Mr. Hamilton and ask him questions, you can present that information. But for now, it is sufficient for the court to understand that there's someone from the company to testify that this record was kept as a normal business practice. Okay. All right. Continue, Ms. Buckle.
Okay, Mr. Hamilton, I'm showing you what is marked Exhibit P5. Can you explain to the court what these documents are? Sean, you have your audio.
You got to unmute for me, Mr. Hamilton.
I'm sorry. This is a monthly account statement. So once an account is applied for and the loan is funded, American Express provides monthly account statements based on the balance that's owed and the minimum monthly payment, and lays out all of the finance charges and things if they were to pay it off early. So this was the very first statement that began May 10th of 2022 with a zero balance.
Okay. And this is the second statement. Explain this one to the court.
Yes, this is the second statement dated June 20th of 2022, and it reflects that the first loan of $18,200 was funded, and it's a request for the first month's installment of $1,653.17 with a payment due date of July 11th, 2022.
Okay. And does this explain to her the direct deposit and the loan repayment period?
Yes, the direct deposit loan number is the account where we put the money into. Okay. The Navy Federal Credit Union account.
Okay. Can you explain this statement to the court?
Yes, this statement is dated July 20th of 2022. It shows that there was a previous balance from the first loan left of $18,336.50, and a new loan was funded of $25,500. And that now the next month's minimum due payment for the two loans combined is $3261.09, and it would need to be paid by August 10th, 2022. And the balance of the two loans combined is $42,511.08.
Okay. And this is the following, no, this is the same thing.
There's something wrong with that.
This is the following statement. Does it show any payments on the account?
This is the August statement.
Mm-hmm.
Oh, sorry, yeah, you scroll down. August of 2022. It shows the total minimum amount due is $3261.09, and we received a payment and credit on the left-hand side under the summary for the previous month's payment of $3261.09. And now the new balance has dropped to $39,577.74 as a result of that payment.
Okay. I'm going to take you to the statement that is December 20, 2022. she basically made several payments. That's correct, right?
Yes, there were payments made on the account. I believe I testified there was the total amount was a little over 42,000. Now we're down to $31,700. So between the two loans, approximately $11,000 was repaid.
Okay.
So this statement reflects the last payment that was received by American Express on the account. On the transaction summary dated January 2nd, 2023, we received a payment of $56.70. And at that time, the balance was $31,016.50.
So that was below minimum due, is that correct?
Yes, because the minimum due payment was $32,7009, plus there was 2 months past due of $6,096.46. So on this month's statement, in order to bring the account current, she would have needed to pay $9,366.55.
Okay, let me take you to the final statement.
Yes, this is the final statement from last month. American Express will continue to generate a statement as long as the balance is still outstanding. And it reflects that the total amount due at this time is $31,785.85.
And that is what we're asking for today. That's correct, right?
That is correct.
Yeah. And this document is American Express record pertaining to this defendant. Is that correct?
Yes, Ulari LLC was the company and Tanika Carr is the individual.
Your Honor, tender exhibit P5 into evidence. I do not have any more questions for Mr. Hamilton at this time.
Can't hear you, Judge.
Sorry about that. Ms. Carr, I will admit P5, and Ms. Carr, based on the information and testimony that Mr. Hamilton has given at this time, including the documents that have been admitted into the record of the court, you have the opportunity to ask any questions regarding this matter that you have. I would just suggest at this point that you ask questions of Mr. Hamilton. If you want to make any statements or arguments, just hold off on that for right now until it's time for you to present your side of the case.
Can he show me the bank account for where it went? Because it doesn't, on the document, it doesn't show where it went.
Yes, the document was redacted so that anybody else that's sitting on the call cannot see your personal information. Your Honor, with her permission, I'm fine releasing the bank account number.
Ma'am, you may need to consider if this is an account that is currently open, that this hearing
It's
is
not
being
my account. I don't.
Okay, Ms. Carr, hold on a second, ma'am. This hearing is currently being broadcast, and so if there was an account open in your name and for Ulari LLC, then this information, if you're asking for him to state the entire account number, it's going to be available to whomever is watching on YouTube, and it's also going to be saved in the court's records. And so if you are willing to waive your right to privacy with respect to the account number, he can give it to you. But that's up to you, ma'am.
Yes.
Okay, sir.
Okay.
You can release the name of the institution and the account number.
Sure. It went to Navy Financial Credit Union, and I'll just say that the last 4 digits of the account number, Your Honor, were, pardon me, 0540.
Okay.
Okay.
All right. Did you have another question, Ms. Carr?
No, I'm going. That's no. Hold on one second. Let me take a second to consider if I have another question before say I don't. Months. 0540. Okay, and then we said, before I asked to see the document where I physically signed, you said, did he have a document that I signed?
It's not an ink signature and it's an electronic signature where you check a, I agree to the terms box and then you type in your name. It's what's considered a digital signature. And those are both, on the loan agreements that we showed earlier, P1 and P2.
Okay. So there's no, so the answer is no, there's no physical signature that you have from me personally, correct?
There is not a pen and ink signature for this type of loan.
Okay.
And to be honest, none of the accounts that we issue in this day and age, do people provide an actual physical, I'm going to take a pen and I'm going to sign my name on the document. It's all done electronically, and the agreements that we have state, when you enter into this type of a loan or a credit card, that when you use the funds provided, that you agree to the terms of the contract.
All right, I think she said that I wouldn't argue that point at that information at this time, whether I did or didn't use it. But let me, do you have, like my ID or any identification verification that I sent in to you?
The information that was provided was your name, your address.
No, my question was, do you have my ID or information that I would have sent in to you?
Yes, through the application process, we received the date of birth, social security.
No,
number.
my identification card. I understand the public information that you have. I'm asking, do you have any supporting documents like my identification that would have been able to validate my signature or anything else that you have?
No, we validated all of the information that was received. But we didn't ask you to give us a copy of your driver's license if that's what you're asking.
Okay. So no signature, account number, no ID. Okay. I'm sorry, Your Honor, for the hesitation. I'm not sure what I can and can't ask, so I'm a little hesitant. But I think that's all I have for him in regards to the information that's presented so far. Is that staying in the lines of what I have the ability to ask right now? Hello?
Hello? Okay, so I'm in on my phone.
Oh,
Because
sorry.
have some kind of glitch on is there anybody else here?
I can hear you.
Okay, Ms. Powell?
I can hear you, Your Honor.
Okay, good. So everybody is here. I'm trying to get back on my computer, but something went haywire. So, all right. So Ms. Carr, I was asking you if you had any questions, any other questions of Mr. Hamilton regarding the testimony that he gave.
I did ask him a few questions. I don't know if you heard them, but I just wanted to clarify that was.
The only question I heard was you asked for him to give the I guess the account location and the account number. And so I heard that and then it went crazy.
Okay. So I asked him if he had a physically signed document from myself, for this, and he did not. And I did ask him if he also had any, if he had received any documentation from me, like identification or anything, supporting, proving who I was or who the person was that took this out, but he did not. So those were, I think, my only questions, if I stayed in the lines where you wanted me to be so far.
Okay.
Your Honor, I would like you to hear my answers and not her. You did not.
I will take your answers. Go ahead.
Thank you. She asked me if American Express had a pen and ink signature on the loan agreement. And I explained that no, that these accounts are applied for online. And then in today's world, pen and ink signatures on agreements are almost obsolete. When American Express receives the loan, like I previously said, we take into consideration all of the information. And if we think there's anything suspect about the application, we're looking at the information provided, the IP address that's utilized to apply for the loan, several pieces of information that we're verifying with national databases. We don't fund the loan. And we would ask for them to provide us with a physical copy of their ID.
But you did
In
not
this
have
case-
it, correct?
In this case, we did not need to do that because all of the information that we received matched. And then
So,
the second.
Mr. Hamilton, hold on a
Two.
second, Ms. Carr. Hold on, Ms. Carr. Mr. Hamilton, for my edification, I guess, I know lines of credit, but usually a line of credit is based on a relationship that exists prior to the establishment of the line of credit. And so if it's with a bank, you're already a bank client, you already have accounts with the bank. If it is with a consumer lender or a credit card or generally, like the person would have to be an American Express card holder prior to then establishing a line of credit. Is that correct?
That is correct, Your Honor.
Okay.
And then the second question that she had asked me is if we had her personal information, which she meant her copy of her driver's license. And my response was no, but we have your date of birth, social security number, the FEIN number for the business. We have the home address that was provided, the email address that was utilized when we were looking at the computer applications that's coming through. All of that information is received by American Express. And again, I don't want to state those items in this public forum
I got you.
for her security.
All right. Ms. Carr, did you have another question?
I was looking for any supporting documents that they had. I heard the information he collected, but I didn't hear any supporting documents that were given that he has.
I guess his response that generally everything is done on the computer nowadays, is the response to that. Did you have another question?
I was looking for documentation because I just wanted some documentation where he got the information from to validate this.
Okay.
No.
All right. Did you have any other questions for Mr. Hamilton before I go back to Ms. Buckle?
Did they upload any? I didn't see anything. Let me see.
So any documents for this purpose would have been electronically filed with the Odyssey function that is through the state court clerk's office. So is that what you're looking for?
No, I was looking for documents for the loan that they secured.
Oh.
But I didn't see any. Is there anything?
Are you asking Mr. Hamilton?
Yes. Does he have any documents that they secured for the loan?
I don't understand your question. I'm sorry.
Any type of physical documents proving that this was taken by me? That's what I'm asking. What
all of the information
besides the electronic stuff, like somebody sitting at a computer, did you have anything physical collected to validate this that you can show me?
All of the information that's provided in the application process is verified for possible fraud through the application process itself.
I understand that, but that wasn't the question.
Well, if I'm sitting at my computer and I'm filling out an application, the only thing.
Hold on just a second. Let me
My phone's gonna die.
All right, I'm back. All right, go ahead, Mr. Hamilton. I'm sorry.
So if I'm filling out an application at my computer, it's not like I'm at the car dealership and I'm gonna hand you my driver's license and a credit card for a down payment, or all of the information that we received related to you and the business was verified that it is accurate through national databases and for fraud prevention software.
So there was no documentation uploaded or provided from myself that you can provide me now, correct?
Well, again,
Your
I don't
Honor,
want to.
Your Honor, I will object. That's asked and answered. She had asked him the same question several times.
Because he's not answering the question.
Well, he actually has, Ms. Carr. I understood his answer. And I think maybe,
So he doesn't have any
so
documentation.
let me
Is
ask
that-
you what,
am
so
I
you're
wrong?
asking for, so if you are communicating with someone by, through the computer, you're asking, is there anything that I emailed you or took a picture of and sent you, or something physical that you had to look at that you received from me? Is that your question?
Correct. That's my
Okay,
question.
Mr. Hamilton.
The answer is no.
Okay.
We utilize the data
I
that was.
understand. I got that part, Mr. Hamilton. Thank you. I don't have any other questions at this time about that part, Judge.
Okay. All right. So, Ms. Buckle, any redirect?
Yes, yes, Your Honor. The account that the funds, both funds were deposited in, Mr. Hamilton.
Yes.
That's the account that it was automatic payments towards the account, right?
So yes, so in the application process, the account that you're asking for us to deposit the money in, we verify with the bank that that account is legitimate and that the person requesting the loan has access to that account. And it's a fraud prevention measure. And so the NFCU account that we deposited the funds into was verified before we ever fund the loans. And then the payments that came back came from that account. So.
And one of the things that the bank also verified is the defendant's address, right? In addition to our social security, onto number and other stuff. That's correct.
Exactly.
Okay. No more questions, Your Honor.
Let me ask this. So the statements that you've presented, the P5 that shows the first statement with the zero balance and the subsequent statements where payments were made, was that statement communicated via computer, like an email, or was it actually mailed? Were the invoices mailed to the address?
So when you sign up for this type of an account, everything is done electronically.
Okay.
The loan agreements, the application, the statements, the payments, it's all electronic.
And did you have a record of where the payments came from?
Yes, the NFCU account, because they're set up as automatic drafts.
Okay, so she wouldn't have had to do anything, or whoever took out the loan, because I don't want to make any assumptions, they wouldn't have had to do anything affirmative to make the payment. It would have come out automatically from the account.
Unless they go in subsequent to the loan being funded and say, I want to pay more this month, or I want to pay early this month, the payments would get drawn on the payment due date.
So the only way that the payments would fail, per your testimony, is that the account was underfunded.
If there weren't funds in the account to make the payment, then they would be returned for insufficient funds, just like if it was a regular check. But once that happens, once a payment isn't received or a payment is returned, then the automatic drafts stop, because it could create a nightmare for a customer. If, let's say, they made a deposit from one of their customers and that check bounced, and we kept trying to collect on an account that did have negative funds because of no fault of their own. So once a transaction doesn't go through, it stops.
Okay, and at the point that there's a perceived default, what action does American Express take?
So once the account goes into default and the payments stop, we continue to send communications to the customer with regard to the past due balance. If I'm not mistaken, Ms. Buckle's office provided those to the court with the initial documents. There were 3 letters.
Okay. All right, Ms. Buckle, I'm sorry, I didn't mean to horn in on your time, but I don't get to sit often as the trier of fact. So sometimes I just need a little bit more clarification.
Okay. Yeah, I did. There was an exhibit P3 that I didn't present based on that, but just Your Honor, I just want to point my witness to this statement because he was explaining to you when it comes to insufficient funds.
Yes.
And can you explain this statement? It's dated
Yes. This statement is dated just a little more.
11, yeah.
It's a statement closing date 12/20/22. And if you look under the summary, transaction summary on the left, you'll see 12/14/22, the payment from 12/11/2022 in the amount of 3261.09 from the checking account ending in 0540 went through the automatic clearinghouse and was returned for insufficient funds. And you can see on the line underneath that it was an automatic draft. So like I previously said, when you sign up for these loans, the money that we deposit the funds into, the account we deposit the funds into, is the same account that we draw the drafts for repayment from. So we deposited approximately $43,000 and we received back approximately $11,000.
Okay. Your Honor, you were exhibit P3. Let me find that.
Your Honor, is it okay to ask questions about this information?
You at the point where I asked if you had any more questions, you said you didn't. Did you have?
I didn't have any more questions for him about the documentation, but I have questions about this payment information that he is.
Well, he's the person to ask
on the paperwork.
Because, yeah, he's the person to ask about all this paperwork. So if there's a question that you have regarding any of these exhibits that have been
That
admitted,
last paper that he just showed.
okay, can we go back to the default notice or the incident of default?
Oh,
the insufficient funds you talk you.
Yeah, whenever the account, I guess the loan became in default, which I guess was this. Go down to that. No. You just passed it.
Before we go to the end, I just want to make sure because the paper that she was just showing was the end, but at the very beginning, she said, or she showed a paper, and he said they deposited 18 something into an account.
Yeah, there's
Nobody
2
made a
loans.
payment.
So, Ms. Carr, what I'm understanding is there's 2 loans. One was made May 23rd of 2022. That's $18,200. The second loan was made July 1st of 2022. That's $25,500.
Because he said, yeah. So I'm not agreeing to that. I'm agreeing with you saying, yes, they said 2 loans. But I'm trying to figure out how they funded a second loan when they said they didn't get a payment for the first loan. So on the paper, she said.
That's a question for Mr. Hamilton.
Mr. Hamilton.
When the second loan was funded, the payments were being made on the first loan.
You said there was no payment made. How do I get to the paper that she had
that was the December
P1 when you were going down?
Hold on, Ms. Carr. Y'all can't talk at the same time. So you wanted P1 or the one where there was a 0 balance after the loan was funded, that first invoice?
Yes, ma'am.
Okay, let's take us there with Ms. Buckle.
P1, Your Honor?
Yes.
Oh, no, P1 is the agreement. You
Oh,
mean,
okay, no, then I guess it was
the first statement?
the first statement under P5.
I thought she showed.
There we go. All right.
There you go.
This was from May of 2022. This was the statement that was issued before the first loan was funded.
Before the first loan. Okay,
Yes.
can we see the next one?
Yes. This statement reflects under the summary of account activity that the $18,200 was funded and that the minimum payment of $1,653.17 would be due by July 11th of 2022.
July 11.
So, Mr. Hamilton, question, if on this statement, if there was a credit card, the American Express credit card, and if that card was in use, would any balance from that card appear on this summary?
No, these are totally separate accounts. They don't get commingled.
Okay, and do you have any information about the status of the underlying American Express card account that
No,
would have
Your
been established?
No, Your Honor, I did not review that.
Okay.
And then my I feel like I'm missing something. Okay, may I see the next statement, please? The next one past the July.
So on this statement, we received a payment of $1,653.17. Both of the loans were funded at this point. You see the $18,336.50 was left from the first loan, and then the $25,500 was added. There were costs and fees, and then when the payment was deducted, the balance was $42,511.08. And then the payment due was $810.22. So that statement that you were looking at that showed the return amount, that was from December of 2022. That was after the loans were funded.
Okay. And you said this came out of an account ending in 0540, correct?
That's correct.
Well, that's not my Navy Federal account. That's
Just ask questions at this time. You don't have to make any statements until such time as if you wish to testify. That's fine, but just ask questions right now.
I'm sorry, I don't know what question to ask. Give me a second.
Were you deployed at any point during this period of time, Ms. Carr? I'm just asking.
No, ma'am.
Okay. Did you have any other questions, or did you, Ms. Buckle may have some questions for Mr. Hamilton?
I do, Your Honor. I was going back to Exhibit P3.
Okay, go ahead.
All right. No. That made no sense.
Okay, Mr. Hamilton, I'm showing you what is Exhibit P3. Can you explain what that is?
So these are the letters that were provided through the electronic process to Ms. Carr. And it devises that, as previously indicated, a payment of $6,096.46 is past due on the Ulari LLC's American Express business line of credit account. Now your total minimum amount due is, including the past due, is $9,366.55. It states, if you bring the account up to date, you may be able to regain access to the American Express business line of credit. However, if you don't make the payment, the business line of credit could be permanently closed, which is what happened in this case. And it also notifies them that not making the payment could negatively impact their personal credit bureau, as well as the Small Business Financial Exchange, which is a commercial reporting agency. This was the third letter, and there were two more. One when the amount was 1 month past due, 2 months past due, and 3 months past due.
All right. Anything else, Ms. Buckle? I'll admit P3 under the business records. Anything else, Ms. Buckle? Shoot. I'm sorry, we're having thunderstorms in this area, and for some reason, power keeps the connectivity keeps wavering. So
Ms. Buckle sent me a message that she's
knocked out too,
and she got kicked out.
So yeah, it's it glitched a minute for me too. So we'll ladies and gentlemen, thank you all for your patience. I know this can be a bit much. Fortunately, because it's virtual, then those of you who aren't currently before the court can do some other things while we are taking care of this hearing. But I do know that it takes a minute to for us to get through these things. So.
Your Honor, in the interim, may I address a matter with you?
Yes, ma'am.
Thank you. Your Honor, as it relates to 2024 CB 02133, that's George Thomas.
Okay.
The defendant is here in the courtroom, and we are both requesting a continuance so that we can address a few issues before it comes back before the court.
So this is Walden Landing. Are you Miss Williams?
Yes, Your Honor.
Okay, so this is Walden Landing versus George Thomas, and this is on a dispossessory. So, Mr. Thomas, if you and Miss Williams are comfortable with a continuance, I'm fine with that. If you all have a consent, please make sure that you file the consent judgment and dismissal of the case.
And that might be the eventual outcome, Your Honor. We just need to verify some information. So we just asked to continue it to the first available court calendar.
Okay, y'all will get notice because I can't tell you at this time when that might be, when my next civil or hearing calendar is.
Great, thank you. And Your Honor, also I have one more matter, and it is Walden Landing v. Rayon Minifield.
All right, is Rayon Minifield present? Rayon Minifield? Last call for Rayon Minifield.
Your Honor, this would be the plaintiff's motion to strike the defendant's answer as well as to issue a writ in stanter, and this would be possession only, Your Honor.
All right, so the court will review to make sure that there was no leave or medical or emergency filed in the case, because we had not received one at the time that the hearing started, to my knowledge. And once we've done that, the court will issue a default, strike the answer, and give possession of the property in stanter.
Thank you, Your Honor. Just for the court's awareness, there's only one individual here in the courtroom, and that is Mr. Thomas.
That's Mr. Thomas. Okay.
I'm sorry,
right.
Your Honor, I got knocked
That's
off.
okay, Ms. Buckle. I've been having some connectivity issues too. We're having a thunderstorm.
Yes.
So that's been an issue. All right, so the letters were presented. I think that's where we were. I don't know if you heard when I asked if there was any information about the underlying credit card, if those amounts or any balance on the underlying credit card would have been reported on these invoices, and Mr. Hamilton said no, that's separate. And so there's no information regarding the underlying American Express account.
Okay.
So that was what I was asking. All right, and Ms. Buckle, did you have anything else at this time?
No, Your Honor.
All right. All right, so Ms. Carr, you're able to present at this time if you have any witnesses that you wish to testify on your behalf, or if you wish to testify on your own behalf, you may do so at this time. All right, I lost you, Ms. Carr. I don't see your video anymore. There you are.
See me? Can you hear me?
Yes, ma'am. Did you wish to ask any to present any testimony at this time?
I just got my Navy Federal.
Okay, that's not the question I asked you. Do you wish to present testimony or evidence on your behalf at this time?
Yes.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. All right, you can tell me anything you want me to know about this situation.
I just pulled up my Navy Federal account number, and it's not that number that he gave. I don't want to give the number. But is that evidence that I can like?
So this is the question that I have, since I got to decide this case. So essentially what I'm hearing from you is you think that someone else took out this account and it was not you.
Correct.
Okay. So, but this account has been pending since 2022. And the statements made by Mr. Hamilton have established that they've been sending I guess invoices, they've had your personal information, all of these things, and they filed a lawsuit that was served. In all of those, in any of those contacts from American Express to you or from the law firm to you, had you in any way, I guess, represented that there was some fraud or an identity theft?
I tried to tell, I don't know who it was. When I called, I got the paper from the court that said that this was going on. And I called the court and they told me to call them. So I called, and when I got somebody on the phone, nobody would give me any information about the debt. Like there was no like the questions that I was able to ask today, nobody would answer those questions for me. So I told the guy on the phone, he just kept saying, "Do you acknowledge the debt?" And I was like, "No, I can't acknowledge it." And then he was like, "Well, we can't talk to you." So that was kind of like a closed door. I went to try to make a report at the police, but they said that I didn't have enough information to give them because I didn't. To be honest, I really didn't know what to go and tell them, other than the fact that I tried to contact these people and that this debt that I don't know where the debt came from. So I really didn't. They wouldn't let me file like a police report or a police file because they said I didn't have. All I could tell them was that they sent me this paper and they said that I owed this money, and that was it. Like,
did you do any research with the Navy Federal?
To be honest, no, I didn't know what to do. Like
they said they got a Navy Federal account in your name and you didn't ask any questions?
I have a Navy Federal account, but that's not my number.
I got that, but you can have more than one account. Did you ask the Navy Federal to give you any information about accounts in your name?
No, I didn't know until just now when he gave those numbers that they weren't, like I can go and ask them now but I didn't know to ask them about
Okay,
another account because I never suspected that there was,
let me ask you this.
I
Do
don't
you
know.
have any connection with Ulari LLC?
Yes.
What connection do you have with that defendant?
So that was just a business that I signed up for. I was doing a credit repair. And I gave the credit repair people my information for that. But that was it.
Okay,
Like I didn't sign up for no money, like
did
no,
you work with anybody on that?
it was like it was supposed to be like a repaired
I get what the business is,
sorry.
credit repair, but did you work with somebody on the business? Like, who referred you? Why did you feel comfortable giving them your information?
I signed up. It was like this event to try to help people. Like they was like doing like a community and I just signed like the initial paperwork. Like they collect your information. They're supposed to call you and talk to you about it and help you figure out what you can do to get set up. But I never paid them no money, so I didn't never.
So
They said it
let me
costs
ask you
money
this.
to participate in that.
So you set up the name Ulari LLC,
Yes.
and you set up that business as an LLC.
Yes.
Okay, and so you had somebody on your behalf, or you did it yourself, set up the company.
Yes.
And the purpose of the company was to do credit repair.
No, that's not that's not the purpose of that company. I gave the credit company the information for the business to try to build the business credit.
I'm sorry, what now?
I gave my business, so my Ulari, I was trying to establish business credit, and I gave the information to. It was a table set up at an event over here in my.
So you gave them your EIN
community.
number, you gave them your social security number.
I filled out the
Gave
entire
somebody,
paperwork, but I never paid them for the
but you
service. So
gave
I didn't
them,
I
listen to me,
didn't, it
listen to
was,
me.
you were supposed to pay for them to help you establish
Okay,
your business credit. Does that
Ms.
make sense?
I get what you're saying to me, but I'm asking you, you gave somebody you met at a table at an event, your EIN number and your social security number and all of your information?
Yes. I was signing up. Well, I thought I was signing up for the credit services.
That made sense to you?
Yeah, I was trying to I was trying to get help to build my business credit.
So the way you build business credit is to get credit in the business name. Why couldn't you do that yourself?
Unfortunately, I was unfamiliar with how, and these people, they had like a little pitch, they can help you, and in so many months you'll be established and you'll
Have
be
you
able
heard
to.
from them since you signed up?
No, I didn't know.
Is any of this making sense to you? Because I hear bells ringing. You don't seem to be hearing the same bells I'm hearing, but I hear bells ringing.
Yeah, now.
And when you found out about this, you were served with the paperwork and you realized that from your standpoint, you're saying that you didn't owe this debt. Did you establish anything with the credit bureau saying that this is not my debt?
I did try to freeze my credit. I submitted like a form, I guess you would call it, to try to like freeze my credit.
And when you did the police report or attempted to do a police report, you weren't able to give them any information about these people at the table at the place where you gave them all your information.
No. I gave them I could only tell them what I told the people that, you know what I'm like.
The best I can do, ma'am, is you might want to, I'm going to have the rest of the hearing. I'll let Ms. Buckle finish, but you haven't established, you've told me that you gave away your credit information, but you haven't established that these people used your credit. The Ms. Buckle has presented information that she has all of your information and somebody, and you're connected to the company, and somebody took out a loan, a line of credit on the company. So from your standpoint, they did exactly what you wanted them to do, only they used the credit for their benefit and they took the money, if what you're saying to me is true. But from Ms.
Yeah.
Buckle's standpoint, on behalf of her client, they've established everything they need to establish that a
But
debt
they
was
didn't, they
the
don't
debt
got
was
no
taken
proof that
out.
I didn't sign nothing for them. I didn't sign anything. I didn't sign no documents for them
Ma'am,
that I didn't.
you gave them two very important numbers that nobody should just give away: your EIN number and your social security number.
I agree.
Connected to your address, connected to your date of birth. So
But every
everything
loan
that
I've ever had, I had to sign for. I had to show ID. These are things that I thought were the standard across the board. I never imagined that somebody would be able to just sit down and be like, oh, I'm going to put this. 90% of the information that they have is available online. Like, that information, most of that information is public knowledge, except for my social security number and the other thing. Like, that's not, I don't understand how they would give you a loan without making sure it's you.
So have you heard recently that a lot of people have had issues with banks, and, they'll say somebody somebody came in and took money out of my bank account, and the bank will say, well, did you give someone your PIN number? Oh yeah, but I gave it to them for such and such and such and such. Well, at that point, the bank says, we gave you a way to secure your privacy and to secure your information, and you gave it away to someone. So now we're not responsible if somebody took your money.
Right. But I would have had to have some sort of agreement with them for them to have permission to use my information. And I never gave them permission
Okay,
to
first
use
of
my
all,
information.
what you're talking about is permission, and what we're talking about is what somebody did. I don't know. You gave them your information. You went to somebody at a table somewhere who said, I can give you business credit. Just give me all of your information. And the same thing that they did to set up an American Express account and get a line of credit, you could have done, but you would have controlled it. You gave somebody that, I don't know why you think they'd be better at it than you would. You set up a whole company, but you didn't think you could establish credit for the business? I'm sorry, I'm picking up a lot of time to try and teach business law, but I don't have anything that disputes what Ms. Buckle's company is and client are able to establish. Now, I'm going to let her finish the hearing. I'll make a decision. You can talk to them about ways to handle this on the back end, but you're learning a very expensive lesson about how to safeguard your information. Because I can't give you advice, but I can point out the ways that things ain't adding up.
Right. Why would they give somebody a loan in my name and not verify that it's me? And then you're right. You're right.
I understand. It's a hard pill to swallow.
They gave one loan and then they gave another loan. Like that is.
Well, because the first loan was the test. Are we going to be able to take the loan?
They didn't even pay it. I understand. I'm sorry. It just don't make no sense. Like how you just, if I go into a car dealership, I can't get nothing without showing them my documentation. This seems weird to me.
Actually, I just had that case on the last calendar. A guy said somebody took his ID and went and bought a car. So that's what he says. I'm not I haven't.
I mean, if they had my ID and my signature and stuff, it would seem like they. I understand. I guess it's.
All right. Anything else at this time, Ms. Buckle?
That's crazy.
Your Honor, I got knocked off, so I wasn't able to put my exhibit P3 into evidence.
Oh,
Yeah.
Go ahead if you wish to.
Okay, I just wanted to ask her something. Your address is 3136 Rex Ridge Circle, Rex, Georgia 30273, right?
Yes.
Carr? And you just testified that your Laurie LLC is your company. You set up that company.
Yes.
And that is a credit repair company, right?
No.
Oh, it's not a credit repair company, but it's your company.
Correct.
And you also testify that you sign up with somebody and gave them your information because they were going to help you to establish credit.
Correct.
Right. So how were you supposed to get in touch with them?
That's what I
After
told
you
her.
sign
I never paid them the money to complete the process, so I didn't get in touch with anybody.
So you gave them
I
all
filled out the paperwork. I turned it in. When I got to the end, they said, "Oh, it's this amount," and I said, "I don't want to pay it," and I didn't do it.
So you
I walked away from them.
You gave them all your personal information without establishing a business relationship with them. That's what you testified?
I just told the judge the same thing, ma'am.
And you say you don't. Where did you meet them?
And down the street at this event
Did you contact the event to at least follow up with the event when it comes to them?
No, I didn't even know that this was a thing. I didn't know that this happened. When I tried to call and figure out where this came from, the people just kept saying, "You owe the money. Do you acknowledge it?" And there was no way for me to acknowledge it. So there was no way for me to figure out that all of this had taken place or happened because I didn't get the information from them.
You got the email exhibit P3 from American Express, right?
No.
So it's not your email address? That's what you're saying now?
What email address did you send it to? This is the information that I called to get before. Nobody would give me any information about it.
After you got the complaint, because the complaint was filed with basically everything. After you got the complaint and you got the contract, did you take that to the police station?
No, I went down to the courthouse and I told the people that I didn't recognize this information. And I filed it at the courthouse and told them that.
No, you're saying it's fraud. By the way, when did you sign up that information with that company that you don't remember?
When did I sign? I didn't even sign up with them. That's what I'm saying. I did not complete the process to sign up with them.
What's not making sense, Ms. Carr, is that you're saying you gave them your entire personal information and don't even remember the date?
I understand what you're saying now. The judge already said that to me.
Your Honor, no further.
I understand what you're saying. I see it now.
Your Honor, no further question.
She said it already. Like, I don't know what else to say. Like, I was signing up for what I thought was a benefit for a business. It wasn't even like, and then I didn't pay for it, so I didn't think that they were going to be able to do anything. If you don't pay for a service, how does somebody provide you a service or do anything on your behalf?
Ms. Carr, because
Yes.
they weren't providing a service, ma'am. They were there to get information to defraud people, if that is in fact what happened. And so I see the frustration on your face, but we have become way too trusting. Somebody sets up a table, they don't even have a business that you can go into. Somebody sets up a table and says, "Here, fill out this form. I'm going to get you credit." And you give them all of the information that you can safeguard. So yeah, some of it may have been available on line, but until you go to them, they don't put all the pieces together, your phone number, your date of birth, the social security card, your EIN number on your business. So they don't have all the pieces to do that, but you didn't get any information from them. You just gave them your information. So them not charging you, it didn't matter one way or the other. Once they got your information, they had everything they needed. Now, I'm sorry that that happened to you. All right. All right. So you don't have anything else, Ms. Buckle?
No, Your Honor.
Okay. All right. So Ms. Carr, I'm going to issue an order in this case. You'll get a copy of the order. Ms. Buckle will get a copy of the order for her client. And if you want to talk to Ms. Buckle to work anything out, then the address for both parties will be on the order. So if you want to get in contact with her, you can go ahead and seek her out, okay?
Thanks, Your Honor.
When
All right,
you say
Ms. Buckle, did you have any information that would help her more easily speak with somebody about resolving this matter?
She could send me an email.
Okay,
I can
go ahead
always,
and
yeah.
chat her your email. So Ms. Carr, Ms. Buckle is going to chat you her email address. So when the chat comes up, you're going to see a red number next to the chat box. So when that comes up, write the information down before you get off the call, because once you get off the call, it's going to disappear, okay?
Okay.
All right. And Ms. Carr, I just advise you, like, certain things you hold very close to you, and do a little research before, you do anything to provide somebody with your personal information. You want to always be sure that it's someone that you can trust. And if you are unsure, you can contact the Better Business Bureau. You can take their information and research them online. You can look for reviews of that particular company. So there are always ways to kind of protect yourself before you engage, okay? Let me know when you've written down the information, and then you'll be free to go.
I have it.
All right. Thank you, ma'am. All right. Ms. Buckle, did you have anything else on the calendar?
No, Your Honor, that's it.
Okay, so let's see. This is the 2 p.m. calendar. I think we've resolved the Walden matters. We have remaining, I believe, Ms. Barksdale, you have a couple of matters on here, and I don't know, I think it's Phoenix Partners and maybe 100 Riverview. Is that correct?
I only have one, Your Honor. Thank you. I have position number 6 with 100 Riverview. I'm not sure who has number 3.
All right, who's, let me see, for number 3, I just wanted to make sure I moved around a little bit because of the availability of individuals. And so Phoenix Partners LLC, Mr. Weinstein?
Yes, Your Honor, I'm sorry to interrupt you. I just wanted to say thank you. Have a very nice day.
Oh, sure.
Thank you, Your Honor.
You're welcome, Mr. Hamilton. Thank you. Thank you
Take
for your
care.
patience. Phoenix Partners versus Trendset Beauty.
Yes, Your Honor, Michael Weinstein on behalf of plaintiff.
Okay. Is there anyone here on behalf of this is a dispossessory. Is there anyone here on behalf of Trendset Beauty and all others? Okay, so Ms. Walker. All right. Did you file an answer on behalf of yourself or on behalf of Trendset Beauty, or both?
On behalf of Trendset Beauty.
Okay. All right. So, Mr. Weinstein, you can go ahead and present I'm assuming based on the name of the defendant that this is a commercial lease.
It is a commercial lease, Your Honor. I was thinking about the fact that the tenant is actually Trendset Beauty Academy, LLC. I don't believe they have counsel. We are ready to present our evidence. I had actually tried reaching out to Miss Walker a little while ago in the chat to see if she wanted to have a conversation before we got started. We had a quick call on Monday and thought there may be an opportunity to get something worked out before having to go in front of Your Honor. I don't know if you have the ability to send us into a breakout room or not.
I do, Mr. Weinstein. So
Okay.
Ms. Walker, let me explain. So if you have a note, Trendset Beauty, I can't see the rest of it. So if this is a corporation, in our court, in state court, corporations are required to be represented by an attorney. But if it's just a sole practitioner, you just use the name. There's different entities that we have to consider. But Mr. Weinstein has given you the opportunity before we have a hearing, if you want to talk to him and maybe y'all could work something out, and that may assist you with respect to how any order of the court affects your business or affects you personally.
Okay.
So did you want to speak with him?
Yes.
All right, so Mr. Weinstein, go ahead. I'm going to put you guys in breakout room number 3,
Thank
and
you.
I'll send that announcement. It'll be an invitation to you, Ms. Walker, that'll pop up on your screen. Now, once you're in the breakout room, if you want to get out, touch the screen again, and it should give you the opportunity to return to the main room or leave breakout room, okay?
Okay.
Your Honor, would you also, my client is on the Zoom. It's his screen name is We Partner. If you would also invite him to the breakout room, please.
All right, I got We Partner, Michael Weinstein, and LaTanya Walker. All right, I'm going to open the breakout rooms at this time, and y'all just let me know if you have an announcement, okay? All right, and Ms. Barksdale, you had Phoenix, and Mr. Pippin, you have Crown Asset. Is there someone here for Janet Strickland and Henry and all others? Cedric Henry? Was that resolved? Janet Strickland versus Cedric Henry and all other occupants. All right, so that appeal will be dismissed. All right, so Ms. Barksdale on 100 Riverview versus Parker and all others. Is there someone here on behalf of Parker and all others? Ms. Parker?
Yes, ma'am, I'm here.
Okay. Is it Aja?
Ahija.
Ahija. All right, so Ms. Ahija Parker is here on behalf of Parker and all others, and that's what it just says Parker. I didn't have your first name on the calendar. And Ms. Barksdale, you're here on behalf of 100 Riverview. Is this this is an appeal from Magistrate Court? Is this a commercial lease or residential?
This is a residential lease, Your Honor, but if you would notice that we had an order for Ms. Parker to pay the rent into the court while this was pending, and she's not paid any monies into the court. We were in court in March, and the judge issued an order. This is actually a transfer case because Ms. Parker filed a counterclaim for $100,000, and the judge transferred the case to your court, state court. And with that transfer, the order required that she pay the rent into the register of the court until this was disposed of, but she's failed to do that. But we're ready to move forward with the entire case today if the judge will hear it.
Okay, so Ms. Parker, 2 things. So you file an appeal from Magistrate Court. So I get to hear the case, what they call de novo, but the appeal has requirements. So one of the requirements for me being able to hear the case is that you pay into the registry of the court any rent that would have been due with respect to the underlying judgment. So if the court said that, you know, the plaintiff is entitled to possession of the property and rent from a said date, and then you say, well, I want to appeal, then you're required per the order of the court to pay into the registry of the court any money that should have been paid as part of the rent to preserve your right to appeal. So have you paid any money into the registry of the court?
No, I have not, but I want to say that I can't really hear you guys fully. It's a alarm going on outside that has been going on for hours, and they haven't came and turned it off. I don't know if you guys can hear it, but I can't hear you guys or think straightly. It's been going on for hours.
We hear you just fine, and I don't hear any alarm, but it's probably because of the weather.
No, this is the second time within a week that this alarm has gone off. The fire department came to the apartment, and
But can you go into like a closet, a bathroom, somewhere where you have the ability to close the like the opening off?
I'll still be able to hear it. It was
Okay,
playing
well,
even louder inside of the apartment. Let me see, can you guys hear it? They haven't came and turned it off. And I think it was not this Sunday, but the Sunday before last, it was going off, and it was going off in the apartment, and it was late at night. It was going off for hours. And
okay, but ma'am, that has nothing to do with what I'm trying to ask you. I hear you just fine, and I don't hear anything in the background. So, I'm not saying that something's not going off, but it's not affecting my ability to hear you and to go forward with this.
Well,
So,
can I text? I think it's the property manager right there. Could she have somebody try to come out and turn it
okay,
off?
that you can contact her after the hearing, but we're here for the hearing on the dispossessory. You filed $100,000 counterclaim. What's that?
Noise disturbances like this, they don't come and fix anything.
Okay, so
And
for a counterclaim, there has to be damage.
there is
And
damage. Yes, ma'am. That's what I was getting to. I haven't stated everything. I'm sorry for cutting you off though.
okay, go ahead.
As well as water damage from the ceiling dripping everywhere. The ceiling is falling in certain areas. And as well as there's a bug issue with roaches and centipedes, spiders and millipedes, and the stuff has came into my personal property as well as my furniture. The bugs have infested into my property.
Okay, so what are you able to document $100,000 worth of damage?
Yes, ma'am.
Okay, what can you tell me what has been damaged in $100,000 worth?
Yes, ma'am. It's a 2-bedroom. I have beds and dressers and nightstands, as well as my sofa and my table, and I have sewing machines and things of that nature and fabric that has been infested into.
Okay. And so how long have you rented the apartment?
Since February last year.
And how much is your rent?
About $1,700 a month.
Okay, and when did you stop paying rent?
Was it August or July of last year, because they have not solved the any issues, and the infestation issue has gotten severely worse. And if I have them, I know everybody else in the complex.
Yeah, I don't, you're here before me. I can't handle anything for somebody else.
Yes, ma'am.
Okay, so do you have receipts that you have had items damaged to the tune of $100,000?
I don't have receipt. You mean like, okay, yes, I have picture and video proof of
Okay, so let's go back. Let me talk to you about a couple of things. So you said you've been renting the place since February. Your rent is $1,700 per month. But there are issues with an insect infestation and water damage. Did you give them notice in writing that you had water damage or an insect infestation?
Yes, ma'am, as well as there being a monthly fee is always charged for a pest control.
Okay. When did you tell them in writing that you had the water damage issue and the insect issue?
Through email. I can't tell you the exact date, but
Well,
sporadically I
can
would
you pull up
email
your
them.
email?
Yes, let me get my phone 1 second.
All right, I'll be back in a second. Ma'am, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. So now you said you have, you've given them notice of water damage. What date was that?
Let me see. Wait 1 second, please. I found the email, one email that dates back to October 2023. And someone in the leasing office stated that the Terminex tech will be coming out, but
No,
also,
what did you say?
I don't know if you see this, but I said that, I'm trying to get to the beginning. Okay, here it is. I said that I'm contacting you because there's a really bad infestation of roaches and other bugs in my apartment. I moved in February and I notified the exterminator and I notified and got the exterminator to come a few times, but they never left. I've spent the duration of my stay living here and spending my own money to get rid of them, even though I get charged for a pest control fee.
Okay, how much do you have records of how much you spent for pest control?
Yes, I have receipts and I have the bottles of different types of spray that I've tried to use, but they have not went away.
Okay, and when did you start treating for the infestation?
I'd say around maybe May of last year when I realized that the solutions that Terminex would come spray and put down into my apartment was not working.
Okay, and how much do you think you spent on pest control?
I'd say about maybe $120 sprays.
All right, so now the water damage, when did you let the complex know that you had water damage issues?
I let them know immediately. It's happened in different places. I would go put in a request on their portal on their website.
Okay, and what in your apartment, what's been damaged by water issues?
My bed in my main bedroom, and then which was coming out of the bathroom in the main bedroom from up under the sink. It was like a pipe bust or something like that. The maintenance man had to come fix that. And then in the second bedroom, there was like water gushing out of the fire alarm thing, the circular one. It was water gushing out. I had to put a bucket down, and that also got on my bed and my dresser in there as well, and my clothes I had on a rack.
Okay, so how much do you estimate that damage was?
With the water damage, I'd say about half of what I'm trying to get, 50,000.
So your bed was,
The water damage cost about half of it.
no, what I'm saying is the value of the bed that you had. What was the value of the bed when you bought it new?
Okay, I'm gonna tell you both the bed and then the bed frame. You want both combined?
Yes, ma'am.
Okay. The main bed, well, I would say it was probably about 6,000 together, but with the bed and then the frame.
Okay, that's your main bed.
Yes.
Okay, and what was the other stuff worth, you
The
think?
second bed is the bed was just about, I'd say maybe like $430 for that one.
$430?
Yeah.
Okay. All right, anything else?
And then the dresser and then my nightstands, I say is about $350 for the dresser and the nightstands. And then the clothes, I collect vintage clothes and I sew as well. So if I put a number on it, I say from the water coming down from the fryer detector, I'd say that was probably about 10,000 in damage with my clothes and my fabric as well on the rack.
All right. All right. Did you have anything else?
It's just been a lot of discrepancies and issues, and it's been affecting me both mentally and it's just been a very disturbing experience. And to know that there hasn't been any help given from the complex, and it's just been a lot of other stuff as well, and a lot of harassment and just
Did you
a lot of stuff.
did you ever indicate to property management that you wish to leave the property because of these issues?
No, ma'am, I asked them to fix the things. I'm not originally from this state, so I wouldn't have anywhere to go.
Okay. All right. So far what I have is $16,800. $16,800 is what you're claiming.
Yes, ma'am. No, wait, we didn't go over this.
And then you said $120 in pest control.
We didn't go over my sofa and my table, and as well as they're in the cabinets. They go, I don't know how they get into the refrigerator. They're everywhere. I can't wake up or walk around, excuse me, without seeing a bug. They literally weaved into every part of not only the apartment, but my life. I go outside and I open my purse and it's one crawling out of my purse. I didn't come here with bugs.
Okay. All right. All right, Miss Barksdale, anything on behalf of your client?
I'd like to ask a few questions, Ms. Parker, please.
Sure.
Ms. Parker, now your lease expired at the property on January of 2024, correct?
Yes, that's correct.
And since January 2024, you have been there on a month-to-month lease, correct?
Yes, that's correct.
And each month that lease renewed, you could have vacated the property, correct?
I'm not sure if that's correct. I never agreed to them to a month to month. I've been waiting to come before the judge so that I can.
You've not signed a new lease. You've not signed a new lease since January 24, have you?
No.
And the lease that you signed with this property was for February of 2022, and it ended in January of 2024, correct?
No, I signed it in 2023.
But it ended in January of 2024, correct?
Yes, that's correct.
Okay. And so you have not signed a new lease to even have you still residing in the property, correct?
No, I have not.
Okay. And you were required also to have personal property insurance, correct?
Yes.
And you didn't have it, did you?
Ma'am?
You did not purchase personal property insurance?
Yes, I did have it, yes.
Okay. Did you reach out to your insurance company for payment of your personal items?
I didn't want to reach out to them because it was up. I was under the impression that since it was the apartment caused the damage, I didn't want to do that.
Okay. And so how did you come to those comparable damages for your bed? Did you go out to find another bed similar to the one that you had?
Yes, ma'am.
And where did you go?
The same place I got it from. I got it from my original the hometown where I got it from.
Where's your hometown?
Jacksonville, Florida.
So you went back to Jacksonville, Florida to look for that same bed?
Yes, ma'am.
Did you take pictures of the bed you looked at?
No, ma'am.
When did you go back to Jacksonville looking for the bed?
When was it? Probably about 3 months ago when I went back.
Just 3 months ago. So today is July. So that would have been in May of this year? May, June, July?
April.
Okay. And
Yes.
so, and you filed this counterclaim when we filed this dispossession was in August of 2023, correct?
Yes.
And you filed a counterclaim to our dispossessory that was filed in August of 2023, right?
Yes, I did.
Okay. And so the last time you paid rent on this property was July of 2023, correct?
Yes.
And at no time did you go into the office to tell them that your bed was damaged, correct?
Yes, ma'am. That's correct.
Okay. And so when you went back to Jacksonville, tell me the name of the store that you visited.
Let me get the Name. The name of the place is Furniture Source. I believe that's the name, Furniture Source,
Furniture Source, and it's located where?
in Jacksonville, Florida, on Blanding.
Okay. And what date did you purchase the bed initially?
I don't remember. I'm not sure.
And what did you pay for the bed initially?
Around the same price with everything included. It was about the $6,000 I said.
So you don't know when you purchased it, but you do know that it was about the same price 3 months ago, right?
No, what I'm saying is that that's about how much I paid for. Can't remember how much the bed was when I went back.
So you just went back 3 months ago, correct?
Yes.
And you went back so that you provide the court with the cost of that bed, correct?
No, I went back to ask them about a warranty.
Okay. So, but you presented to the court today that that bed was worth $6,000.
Yes, I have receipts I can find of the bed and the stuff costing that much.
Did you file those receipts with your counterclaim?
No, I wasn't sure how to file it online, as well as my pictures and evidence of the damage.
Okay. And do you have any receipts for pest control damage to your property?
You really mean like me going to get outside sourced pest control?
Yes, ma'am.
Not of that, but I have receipts of me purchasing products from the store.
Okay. So did you tell the court that you purchased products, or you went out and got outside sources?
I told her that I purchased the stuff.
Okay. And how did you come up to the cost of 120?
The receipts.
Okay, where did you go purchase it?
I've been to Home Depot. I've getting, I think it's an ortho treatment. I've got a lot of bottles of those. I went to Target and they have different types of sprays. One that I can call out is a peppermint bug spray that treats different types of bugs that's supposed to keep them away. And I've been to Walmart and have bought bait, as well as I think it's boric acid that's supposed to they're supposed to ingest it and then die. So yeah, I think those are the main 3 stores that I've bought things from.
Did you give a date on when the property started leaking?
It's happened sporadically. So whenever it happens, it's like, it's never nothing that's like, how can I say? It's never nothing that's small. It's always something that's big. So I have to call them immediately or email them so somebody can come out and fix it then.
Give me a guesstimate of the first time you called them about the leak.
It was probably around May or June last year. The ceiling in the kitchen was leaking. And then they came in. I don't know what they did. It just seemed like they just painted over it.
Okay. And are you still in the property?
Yes.
Is the property fit to live in?
I don't think so, no.
But you're still there?
Yes.
And we filed this dispossession August of 2023, right?
Yes.
And is now, tomorrow will be August 1st, a year ago.
Yes.
It's not fit to live in, but you're still there, right?
I don't have anywhere else to go.
Okay. Judge, I have no further questions for her. I would like to ask my client a few questions, Judge.
Yes, ma'am. All right. Ms. Barksdale, you can go ahead. Your client's name?
Miss Ashley Amiger.
Amager.
Amager. Please
Okay.
raise your right hand.
Yes.
Do you affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And you're Miss Amiger?
Amager, yes.
Amager. And you employed by 100 Riverview Owners Day Rise Residential?
Yes.
And what is your position?
I'm the property manager here.
You're the property manager?
Yes, ma'am.
Before today, have you met Miss Parker?
Yes.
Okay. You heard what she testified about leaks in the property. Tell the court what you know about leaks happening in this property.
The only email that I received, not email, I'm sorry, the only work request that was put in regards to any leaking for the ceiling was done on April the 24th, 2023. And at that time, she was leaking and we came out and addressed it as she did say. The vendor, when they came out, they assess the damage, wait till the water dries, make sure that there's make sure there's no further leakage. And then from there, they'll repair the damages.
Was there, based on April 24th, 2023, when she had that leak, do you recall what date you all repaired it? How long was it after the time she called it in, or you knew about it?
Give me 1 second. I can find out based upon when I have the invoice. Give me 2 seconds and I'm gonna pull that up.
Just 1 second, thank
you. Sorry.
Okay.
The rain has got my system moving a little slow, so bear with me. Here it comes.
Okay.
Four 2023.
Hold on, the judge is off the bench. Hold on.
Oh, I'm sorry.
All right, I'm sorry, continue.
Okay, Miss Amiga, can you tell the judge, you said she called in a work order for the leakage on April 24th, 23, correct?
Yes.
And what date did you all get it repaired?
The contractor came on 4/27/2023.
And was it repaired on that day?
It was.
And since April 27, 2023, did you have any more calls for that particular leak?
No, I did not.
Did you have any calls for pest control?
Not to my knowledge, I have not. I can pull my pest control records to see how many times she's been placed on pest control, but they have to request that. And they have to request that prior to Monday coming.
Okay, so you, off the top of your head, you don't know if she's requested?
I believe once or twice. I think she had a clean out. Hold on 1 second, I can tell you. Give me 1 second.
And while you're looking for that, what is the clean out?
Is where they come in and they suck up all the roaches out of the cabinets, appliances. They pull out the.
Never happened. That has never happened. I'm sorry to interrupt you, but that
Ms.
has.
Parker, you can't interrupt her. She let you talk and she didn't interrupt you
Yeah,
at
I'm
all.
sorry. I didn't know that, but that has never happened. I'm sorry. I'm gonna go back on mute.
Thank you.
So what is the suck out? A clean out?
So the clean out is where when they come in, they'll suck out all the roaches out of the refrigerator, out of the dishwasher. They pull those out. They pull out, as long as the resident has cleaned out all cabinetry of their own personal items, they suck out the roaches from there too. They go in any cracks, any crevices they can, and they pull and they suck them out into this vacuum. The resident has to be out of the home for a minimum of 3 hours for this procedure to take place because of the extensive amount of time and work and chemicals that they use.
Is this a service that you request or is it automatic?
So it's a service that they can request, or if we've noticed that they've been put on pest control quite often and they continue to have issues, we will suggest it for them and we will go ahead and reach out and let the resident know. But there is a form that they have to fill out in a checklist.
Do you see her record where she called in for pest control?
I'm grabbing the file now. My assistant is grabbing the binder for that.
Okay, let's move forward because it's time. Okay, and so other than that, the leak is y'all repaired within 3 days and you've not gotten any more calls on it. And that's all you did. Did you go on the property yourself during that April 24th or 27th time?
I did not. And soon after, go ahead.
Did she report anything about personal property damage?
No, ma'am. Not to me.
Okay.
She did not.
Okay. Your Honor, I'm satisfied with her testimony. I know this time is
grinding down. So I'm satisfied with that.
All right, Ms. Parker, did you have any questions of this witness on behalf of the complex?
I can only ask questions.
Right now, yes, ma'am.
Okay, you said that that this apartment received a clean out, but do you have any proof showing that? Because I never received that, and I never even knew that I could request a
Is
clean
there a
out. I
question,
never got
Judge,
that
as
in
she
writing.
testified? If she would please ask the question.
Yeah,
I
ma'am.
asked a question. Could she have any does she have any evidence showing that I received the clean out?
Okay.
That's what we're currently looking for now, to see if she did receive the clean out.
And I also have a question. In the lease it says that monthly there's a pest control fee. If there's a pest control fee, why is there still pests present, and why isn't there any preventative measures taken to ensure that if money is being paid for this service, why isn't it anybody making sure that they're not present?
Well, one, as is stated in your lease agreement that you signed, it states that you have to inform the the leasing office to let us know that you want to be placed on pest control. And it's also your responsibility to keep and maintain the cleanliness of your home. So again, I can't testify to why you're still having an infestation.
And if I was able to present proof that the entire building that I'm in is infested, well, how would you go about that?
Yeah, I'm gonna object to the entire building. She can only present her unit. So I would
Yeah,
object
that's
to
what
anything.
I wouldn't be able to ask my neighbors to.
We would object to her neighbor.
Ma'am, if you didn't have someone prepared to testify at this time, then we need to move forward with the testimony that we have. But your neighbor's unit is separate from yours. And so there might be different conditions that have no bearing on yours. The level of cleanliness and different other factors might have a bearing. And so because you're the one who's suing, we need to examine what has happened with your unit and with what you've done and what they've done in response to things that you've told them. Okay.
Can I say something? No.
That's up to Ms. Barksdale.
No, ma'am.
No, I'm okay. Thank you. It's fine.
All right. Anything else at this time, Ms. Parker?
I don't have any other questions. Will I have a chance to just speak again?
Well, you can speak now if you want to.
Okay, excuse me. She stated that I don't remember which one of you said it, but y'all said that it's relating to my unit and the cleanliness as well as just my upkeep of the apartment, but they're outside as well. And there's like holes everywhere, and they're coming in and out from like there being openings for them to get in, and there's as well as there being mold in the windowsills and in the tubs, and just I don't know, it's just been a lot.
Right. So anything else at this time?
Is there a way that I can present images
if you wish to? You can share screen, but I'm not sure if how that works if the images are on your phone.
I sent them to my computer.
Okay.
Do you
any objection, Ms. Barksdale?
None, Judge.
All right. Go ahead. You would pull them up first and then share screen, because if whatever you share screen on, we're gonna see. So
do you know what I would click on in order to share my screen?
If you touch the screen on your computer, you should see at the bottom icons and one of them in green says share screen.
Okay, I see the arrow in the green. Okay.
And while we're doing that, Mr. Weinstein, did you and Ms. Walker come to an agreement? Ms. Walker, Mr. Weinstein?
Sorry, Your Honor.
That's okay.
I just stepped away for a minute.
Sometimes that's a good thing in the
Hello.
beginning.
Did you all reach an agreement?
We did, Your Honor. We've agreed on a consent judgment.
Okay. If y'all agree on the terms, go ahead and draft it, send it over to Ms. Walker, and then send it to me and I'll sign it.
Okay, can I just make the announcement in court?
Sure.
Okay, we've agreed that the consent judgment is going to be in the amount of $60,000 all in. And Ms. Walker is also agreeing to vacate the property on or before August 15th of 2024. And if she does not, then at that point in time, we would be able to request the court to issue a writ of possession. I will have my office go ahead and prepare a consent order. We will get an email to Ms. Walker. I just wanted to make sure that it was announced in court just in case there are any issues in
All righty.
getting it. But that's all we got.
All right, Ms. Walker, does that make sense to you?
Yes, ma'am.
All right, okay, then you all are excused at this time. Once I get the document, I'll go ahead and sign off on it. We'll file it and you'll each get a copy, okay?
Okay, thank you, ma'am.
All right, thank you. All right, I'm sorry, Ms. Parker, you were gonna share screen.
Oh, my goodness. And you know what, where it's really bad? 70.
Hearing somebody else. Okay, go ahead.
Oh, I'm sorry. I was on mute. I was speaking. I was saying, yes, I'm pulling it up now.
Hmm. Hmm.
Uh-oh. Okay. Can you guys see?
I see your, like, so that's what I was saying. You need to pull the pictures up, and click on those, for us.
Can you see this?
I just see small, tiny pictures. I see what you're showing us, but I just see tiny pictures.
Okay, what about this? Can you see this?
I just see tiny picture, like a series of tiny pictures.
Okay, it says pause. It says that your screen sharing is paused. I'm trying to see how do I unpause it. It's an orange.
I didn't do anything, so I don't know how to.
Can you see now? It's green.
I just still see the small pictures.
It's paused. 1 second.
All right, I don't see anything at this time. Is there anything else that you have, ma'am? Okay, I see a video.
Okay. This is some water damage, and it took a while for them to come out. It was gushing from up under there, and it was hot water. Okay, how can you turn it off? Because I'm not even seeing what it's called. Okay.
All right.
And then, is it still sharing?
No, ma'am.
Oh. Can you see this?
Yes, ma'am.
Okay, I think I could just do it like that. Move these out the way. I'm sorry for the delay. This is water dripping after the gush came from this fire detector in the second bedroom.
Okay.
Okay. And then the first video I showed, this is when the maintenance guy came out and he had to first I had to put down newspapers to stop it because it was gushing out so bad. And this is the part that he had to replace. I think he said something along the lines of that. I think it was a valve. He said that.
Okay, but you don't have to tell us what he said. You're showing us the pictures.
Okay, that's the part he had to fix on the first video I showed up under the cabinet.
Okay, so you said that there was damage to your property. Do you
Yes,
have pictures that show that?
I don't have any pictures of the property. I just have pictures of the stuff happening. It's
Never
been
took a picture of your bed, never took a picture of your sofa.
I took pictures of the stuff as I seen it happening, like the bugs crawling and the water gushing, not
Not any damage to the particular property item.
No.
Okay. All right. Anything else at this time, Ms. Parker?
Yeah, I don't know.
Okay. Any questions for Ms. Parker, Ms. Barksdale?
Well, I do have one more thing to say. I'm sorry.
Yes, ma'am.
Okay, when I first moved in, they give a paper for me to state everything that is wrong, and the things that I wrote down, they had never came out and fixed. And well, they sent the guy out, and I don't think he no longer works here, but when the duration of him working here, he never came back to fix anything.
Okay. All right. Did you have anything else at this time?
No, not at this time.
All right. Ms. Barksdale, did you have anything else at this time?
Miss Ashley. Miss Ashley, you're on mute.
Wait, I'm sorry. I'm gonna let her go then. Can I go after her?
Okay, Ms. Barksdale, I think what I didn't get was what is the amount of the
That's what I was trying to get to, Judge. Miss Ashley, what is owed from August 2023 through July 31st, 2024? What's the total owed on this account?
She currently, yes, ma'am. She currently owes $23,194.06 as of today.
And if you were asking for a writ on August the 8th, which will be 7 days, that would be 1720 divided by 31 days. That's 55.48 a day times 8. That's 443.87. And without any other fees with the utilities, that would be 23,194.06. That would be 23,638.03. 23,638.03 through August the 8th, with just rent and no other fees for August.
Yes.
Okay. All right. Right. Anything else, Miss Parker?
Okay, when I was asking questions, I didn't get to state that that I have not had any clean out as far as her saying that that's what they do for bugs. I wasn't even aware that that was a thing. Every time I requested pest control, they just came and sprayed and put bait down. As well as it's just been a lot of wear and tear on my mental state. It has affected me greatly, and I've been harassed. It was one property manager that has came out with a man and jumped the balcony and was banging on the windows and doors.
Yeah, I'm gonna object to that. We don't know who it is, and nobody's here to testify.
I have a picture of them walking, and
All right, hearsay, Judge.
So, Ms. Parker, I think we're getting a little far afield from what's going on. Okay, so this is what the court is considering. The fact that you've been in this place without a lease since January 24th of 2024, that you failed to pay rent on a month-to-month basis. So essentially, when you're month-to-month, it means that you have not signed a new lease, but the same terms apply as the old lease. The only thing that changes is the notice provision and the amount of time that they have to give you to get out of the apartment if they want to evict you, or if they want to end the lease contract. But if they want to evict you, they can do so for failure to pay. In Georgia, the law is that if you are occupying a property, then as long as you occupy the property and they can't rent it to somebody else, you owe the rent. Now, if there are issues with the property and you spend money to correct those issues, or the property is such that you can't live there and you have to leave, then you can get damages for as an offset to what is owed on the rent. So if you already owe rent and you're still in the property, but you're not paying that rent, the amount is still going up of what you owe. If you have given them notice of something and they haven't fixed it, and you've had to fix it yourself, then you can get an offset against that rent, but you probably don't have I'm gonna tell you, you don't have enough to equal $100,000. What you've shown me is that when you gave them notice of the water issue, someone did come out and he was replacing a valve or some part of the system where the water issue was addressed. So you gave them notice, there's water issue in my place, someone came out and addressed it. You have pictures of that. You also said that for pest control, that you were being charged a fee for pest control. You spent money on pest control. The things that they didn't assist you with getting rid of the insects, and you spent $120. So far, you've established damages of $120. You haven't been able to give me any information with respect to your clothes. You testified that you suffered $10,000 in damages, but you didn't take any pictures of them. You didn't give a receipt for the bed that you had. The timeline seems a little iffy, and a $6,000 bed seems a little bit excessive. And you're not able to pay $1,700 a month in rent. So I'm just gonna be honest with you.
I'm sorry.
Hold on. From a practical standpoint, you've shown the damage. I didn't get anything else about any lasting water damage. But as a practical matter, I'll give you $500 as an offset on your counterclaim to the $23,638.03 that you owe. So the judgment would be in the amount of $23,138.03. And you've been in the place without paying since January of 2024. That's a breach of the lease agreement because you failed to pay, but you didn't leave the premises. As a result, the court is going to issue a writ of possession to the plaintiffs, Phoenix Partners, for you to leave the location within 7 days, which would be on August 8th of 2024.
Can I speak now?
Yes, ma'am.
I was under the impression from the Georgia tenant handbook, I believe that's what it's called, that I can withhold rent when they're not handling repairs.
Ma'am.
Unless
it's changed since I was in magistrate court, no ma'am. You can make repairs and you can withhold the amount that you spent. But you can't withhold the total amount and still remain in the property.
Okay. Yes, ma'am.
All right. Anything else, Ms. Barksdale? Am I incorrect in anything? Because I'm sure you'll correct it.
Well, I'm gonna have to let you have it today. We would ask for the appeal provision in the order, Judge. Do you want me to prepare the order or would you like to prepare it?
You can prepare it.
Okay, I will send it to Val.
All right, and so Ms. Parker, the appeal required you to put money into the record of into the registry of the court. If you plan on appealing this, I'm telling you, you need to pay the $1,700 a month into the record of the court. You need to catch up the $23,138.03 that the court granted in judgment, and then pay any additional monthly amounts until such time as the case is resolved fully.
So, if I pay the money into the, what did you say it's called again, please?
The court's registry. So you would have to pay the entire judgment of $23,138.03, and then each month after that, you'd have to pay the $1,700 monthly rent in order to maintain the appeal. If it's not paid, your appeal won't go forward and my judgment will stand.
Okay, I understand. And as far as the Georgia Tenant Handbook, is there any way, is there any way that I can show proof of that, the information I found?
Ma'am, I can't tell you what the Georgia Tenant Handbook says. What I know the law to be is that if you have an issue that you've given them notice of and they have not addressed it, and then you've taken your money or your effort to correct that issue, you can withhold that portion that matches the amount that you spent or paid someone to do it. But you didn't pay somebody $23,000, meaning that you withholding everything since January. Now, if I've incorrectly stated the law, Ms. Barksdale, as an officer of the court, you will correct me. Is that correct?
They're paying rent as a separate covenant from repairs. You're expected to pay the rent. You're expected for us to do the repairs, but you cannot withhold rent for repairs and remain in the property.
Yes, ma'am. It works differently in other states, but here in Georgia, if you're in possession of the property, you have to pay rent.
Okay.
So that's why I treated these things separately. Their claim for rent, your claim for damages. I heard your claim for damages. I took what you have proven in damages. I applied that against the rent owed. I gave you an offset, but it still equates to $23,138.03.
Okay.
All right. Ms.
Thank you,
Barksdale,
Judge.
you're welcome. If you'll prepare the order and the writ.
I will.
All right, thank you.
Thank you. Mhm.
You're excused at this time unless you have something else before the court.
Nothing further, Judge. Thank you.
I think thank you all for your patience. I think we're down to the last case, which would be, Janet Strickland versus Henry and all others that I called that case. They did not appear, so the appeal is dismissed. And then Crown Asset Management versus Michael Whitney. Mr. Whitney, can I see you, please? Thank you for your patience, Mr. Pippin.
Yes, ma'am. Thank you for your patience, Judge. It's one of those days.
Yeah, I just try and take it slow and explain everything as I go. I don't like for people to leave here at least not knowing why I made the decision I made.
Yes, ma'am. I understand, and I think the explanations are very helpful. So I get it, especially for the pro se people.
Mr. Whitney, are you having technical trouble?
No, ma'am, I'm here.
Okay.
I'm sorry about that.
Can you show me your image?
Yeah.
There you are. All right. So Mr. Whitney, Mr. Pippin, this is Crown Asset Management. Mr. Pippin is here on behalf of the plaintiff versus Michael Whitney, who is pro se. It's a counterclaim. It's a contract breach of contract claim and a counterclaim. So Mr. Pippin, if you'll give the court the information regarding the claim, and then I'll hear from Mr. Whitney on behalf of the counterclaim.
Yes, thank you, Your Honor. Again, Joe Pippin here for plaintiff. Judge, I know it's late. I'll be very brief. This was
That's
a
okay.
loan.
Take the time that you need. This is what I do. So
Yes, ma'am. Okay, thank you, Your Honor. But it is very succinct. This is a personal loan that the defendant requested. It looks like February 7th of 2022. The creditor was Cross River Bank. It was a loan for $5,000 with an 8.97% APR, finance charges of $725.80. So the total that was to be received per the loan terms was $5,725.80. Payments of $159.05 starting on March 10th of 2022. I'm looking to see the date of the last payment. I had it earlier. It was shortly thereafter, Your Honor. It was in 2022. I'm not trying to hold up the court. At some point in 2022, the payment ceased. Subsequently, the account was closed. It was transferred, Your Honor, and I believe attached with the plaintiff's business record affidavit, that certificate of sale of accounts was also filed. And in case that's, defendants, I anticipate will argue that he's had no relationship with Crown Asset Management. The account was acquired by them from Cross River Bank, the original loan that he had. And I believe that's, Judge, that's about it. As if I can may briefly, though, address the counterclaim that is going to be brought.
First, let me understand. So the entire amount that you're asking for on principal is $5,721.80.
Just double checking. I'm double checking, Your Honor. That was I'm sorry, I had several things open and accidentally closed it. Sorry, Judge. Let's see. All right, let's open the other one. Let's see. Complaint. Yes, that's correct, Your Honor. Actually, just $5,000 in principal and court costs.
Okay, so they're only asking for the initial loan principal and court costs in the amount of.
I'm showing 214. No, see, I'm sorry, Your Honor. 266.
$266.
And that's it.
All right, Mr. Whitney, go ahead and tell me about your counterclaim, sir.
Oh, my counterclaim comes from. Let me get my notes together. Sorry about that. So basically, I believe Crown Asset Management, well, is this right? Well, it was Reagan and Reagan, because that's who I was communicating with. Feel like they just conspired and unlawful, asserted debt in a scheme to defraud my personal property.
Okay, so sir, just tell me what you're asking for and why. You don't have to read from it, because it'll be a lot easier for me to understand what you're saying if you just use plain language.
Okay, so you said as far as what I'm trying to countersue for, like the amount?
Yeah, tell me the amount you're suing for and why.
Yeah. The principal, I was doing $350,000.
So you wanted $350,000 from them?
Yes.
Okay, and why?
My reason is, so my reason would be is because I just feel like what I've noticed, the CAM LLC is like they're violating public policy and personal rights as far as attacking people who they feel like probably ignorant to the law, who can't represent themselves. And they do this all the time after I've done my research. It seems like this is what they do. It's like how they make their money. They go purchase debt from people probably from low-income areas, what I've seen, and they want to come for them. And I feel like remedy must be demanded for that.
Okay, so if I told you it was legal for individuals and companies that have debt to sell it to other companies that wish to purchase it, And those companies can thus pursue the debt under either a purchase agreement or an assignment, then there would be no basis for your $350,000 claim. Are you denying that you owe this debt?
I feel I extended my
No,
credit to
not
them.
what you feel. Are you denying that you owe the debt from
Yes,
this
yeah, I'm
loan?
denying. Yeah, not that I owe
Okay,
them
so
debt.
you're denying that you took out this loan and failed to pay.
Yes.
Okay, Mr. Pippin, do you have anything that shows Mr. Whitney's connection to this loan?
I do, Your Honor. Believe attached with the summons and complaint, in the business records, we have the contract he signed. Looking here, bear with me 1 second, Judge.
No problem.
Page 70. Let's see. I know the court has received a lot of documents on this one. Let's see. Okay. The how do I close it? I had the contract. Here we go. Signature page. Now it's DocuSigned, but as you know, I'm sure Mr. Whitney's been listening to other cases. A valid an electronic signature is considered valid, and this document was DocuSigned electronically. It looks like here February 4th of 2022, requesting the loan. The funds were transferred to Mr. Whitney. Therefore, he did receive the benefit of the loan, and then failed to pay on it.
Were they
So-
transferred to an account or were they transferred by a check?
It's a great question, Your Honor. I'm looking to see. I'm not certain, Your Honor. I'm not trying to hold up the court.
No, that's okay.
Okay, yeah, us too. Thank you.
Let's see. I'm sorry. Were people passing by, Your Honor? Let me mute for. I'm sorry, Judge. I'm pulling it up here. I'm seeing that
Are you able to share screen?
yes, Your Honor. I'm glad to. Let's see here. Let's see. Okay. All right. I believe, Your Honor. Can you see that? This is can the court see this okay?
Yes, sir.
All right, that's the signature page there. 2/4 of 2022, DocuSigned by Mr. Whitney. It also does say, I agree to pay Cross River Bank all sums disbursed under the terms of this loan agreement. I acknowledge I've received and read the disclosure statement. And I'm looking to see how the funds were transferred. That was February 4th. This right here, this shows the final demand. So multiple attempts were made to work with Mr. Whitney, and and try to get this account caught up.
Were the notices sent by mail to the address on the screen?
Yes, Your Honor.
Okay, so this wasn't one where they were just emailed.
That's correct. The North Hill Court address. Yes, ma'am.
All right, and when Mr. Whitney was served, was he served at that address?
Let me look through and see, Your Honor. Yes, that is the address listed on the summons and complaint.
Okay. All right, and did he respond to the summons and complaint?
My understanding is, I believe the response was the counter, let's see, the demand for full disclosure. Okay, yes, there was a response. That's what this is, Your Honor. And it appeared to plaintiff that there were about these, we treated these as interrogatories, Your Honor. This is the defendant's response. There's
Okay.
50 questions, all of which were responded to. And then he alleges all these damages, and I believe that's how he gets to the 350,000 number. Again, Judge, these are all completely unliquidated, and the plaintiff would argue these are baseless. Defamation, intimidation, conspiracy, racketeering. There's a lot of crimes alleged, and illegal activity, none of which has taken place.
Okay.
So
did he reference an address on this filing?
I'm looking to see. Yes, ma'am. Right here, this is what he prepared, this 12404 North Hill Court.
Is that the same address on the contract documents that you have?
I will scroll back down and look, Your Honor. Yes, ma'am.
All right. Mr. Whitney? Do you have any
Yes.
questions about this document?
Yes. So, let's see. So that's the, I believe it's the Cross River Bank document. Can't really see it.
Well, it's the Cross River Bank document and also your response to the lawsuit.
Yeah, my counterclaim. I have questions about, let me see, I'm sorry. Let me get my stuff.
Was
So
that hold on. Was this a,
return receipt?
yeah.
Yeah, I'm not sure, I can't read it.
Well, it says that it was addressed to Michael Whitney Jr., 12404 North Hill Court, Hampton, Georgia, 30228, and somebody signed for it.
Yes, so I put in demand for the full disclosure before I was served. So we started communicating before I was actually properly served. So I would like to look at the dates. I was served in February.
Okay, so let's go back a step. So the $350,000 counterclaim, the court has reviewed it. I'm just making Mr. Pippin put it on the record, but sir, there's nothing in there that you can prevail on. Most of those are like criminal matters. You just went through some internet search and found a bunch of stuff, but none of it is really relevant to what I have to deal with today.
So, could you repeat that how lawful it is for them to a debt collection agency to go buy the debt and without my consent?
It's allowed, sir. It's just like when somebody buys a house. Almost before you close on the house, they're going to sell your mortgage to some other servicer. So if you've ever bought a home, once you close, you may close with one mortgage company or bank, but by the time you get your first payment out, they have sold that debt to someone else as a servicer of the debt. And they've taken the money and what money they could get from this bundle of debt, and they move on and they go somewhere else. So is legal, not only is it legal, it is so commonly done, it's not even a thing that people worry about. The only thing I have to worry about is that there's something that shows the assignment or the sale between the company that issued the loan and the company that bought or was assigned to collect the loan. Mr. Hippen's clients have provided that information in the court's record. If they had not, we would not be having this hearing, or I would have brought it up at the top of the hearing, because it's part of what we look for. So yes, sir, it is legal, fully legal for any company that has debt and holds a loan that is owed by someone else to sell that loan to someone else or some other business to collect. Happens all the time.
And if I may, Your Honor, that's exactly what happened with my own mortgage. It was a year after I bought my condo, it was transferred. And that didn't mean I didn't have to pay the mortgage. I just had to pay mortgage company B instead of mortgage company A.
Yeah.
Yes,
so
ma'am.
It happens.
So, okay, I have a question. If I could ask a question.
Sure, Mr. Whitney.
So, okay, so from my research, I have found out that basically, so when I extend my credit, does not make me the creditor?
No.
So, like,
You're the debtor. You're the
I'm
debtor.
the debtor.
Yeah.
So, okay, so pursuant to 12 CFR 215.3, like that doesn't interpret that when a person extends their credit, they're the creditor?
Sir, to extend credit means that, so it's like a credit card. If you have a credit card and you take your credit card and you buy something at a business, the company, American Express or Visa, is the creditor because they are extending you credit to purchase. So they're saying he's going to purchase with our card. We're going to handle getting the payment on the back end. He's going to pay us. But business, go ahead and give him what he's asking for because he holds this credit, this card that says eventually we're going to pay you and he's going to pay us. So they're the creditors because they have the credit. They're extending you the credit in order to purchase. And then you are supposed to pay them back for the credit they extended you. You're the debtor, they're the creditor. Mr. Whitney,
okay.
You have gone all down the wrong road, sir. Did you go to anybody who could explain this to you instead of just doing your own research? You know what professionals hate to hear, what doctors hate to hear, what lawyers hate to hear, what anybody who has professional skills and abilities is for somebody to tell them, I've done my own research.
I'm trying to confirm now. I just want to ask questions about these certain laws that
I'm just saying, there's a lot that goes into understanding legal issues, and you've seen me on this hearing. So you've seen me. I'm not going to railroad anyone. If it is not correct, I'm gonna tell you it's not correct.
Yeah.
If it is something I need to explain, I'm going to explain it to you because I don't want anybody leaving here thinking that they have been mistreated by the court or they don't understand what's going on. But when I tell you I've done my research is what causes nightmares for anybody, judges, lawyers, doctors, anybody who has been trained in a certain area, and then they have somebody who said they went on the internet and they found some stuff. When I tell you, it drives us crazy because it took me 4 years in law school, 4 years in college and 3 years in law school, and then practicing for years and years and years to get all this under my belt. And I still have a book. I have a computer database that encompasses a whole wall full of books and statutes and rules that I have to go to and I have to understand. Now, the reason I know this area of law so well is because I spent 4 years in magistrate court, and most of these cases usually come through magistrate court. So I've dealt with this, not only the 4 years I spent in magistrate court, but the 9 years I've spent on this court. And when I tell you, when somebody says, I've done my research, and then they start quoting and citing to federal regulations or federal statutes that don't apply to what we do, or they're citing to UCC when it's not what we're talking about, then the problem becomes how to make you understand and get you back on track.
Oh, that's correct. Okay. Now I understand what you're saying. I definitely do. So basically, like the USC laws wouldn't apply in this situation.
This is a straight contract issue. Straight contract. The contract began when the company, the bank loaned you the money. The contract says they're gonna lend you the money. You're in exchange for that, you're gonna pay it back with interest. Your interest rate was 8.97%, and then there was some fees that the bank charged to make the loan. They're not even asking for the fees or the interest. They're just asking for the $5,000 principal. So they're willing to give up $725.80 plus whatever was owed since the time you failed to pay. And because of that, they just want $5,000, and then they want $266, which includes the filing fee and the service fee. Am I correct, Mr. Pippin?
That's correct, Your Honor. That's all.
So they're not even asking for interest. They're not even asking for the bank loan fees. They're not asking for any of that.
And no attorney fees either, Your Honor.
They're not, yeah, they could have asked for attorney's fees. They're not asking for that either. So I'm going to deny your counterclaim for $350,000. And B, unless you can tell me something different, they've established what they need to establish, that there's a contract present, a loan was paid, the loan was made at an interest rate of 8.9%, and there were fees due for the loan origination. The loan was not paid back, and they're asking for the original principal of $5,000 plus court costs.
Okay. So also, I don't want to get upset. So also, does the truth and lending apply?
It's just, people
I'm just trying to
say,
understand. I want to know. I'm intrigued by it. I really am. Like this whole thing got me into doing my research. I didn't care nothing about none of this until I found out that I was being sued or whatever.
I get that, but research without context. So there's a gajillion things on the internet, not all of them true and not all of them relative. And so just being able to Google something doesn't point you in the right direction of where you should actually follow for what's going on here. So you could get a ton of information from the internet. That's how you ended up with a RICO claim in your counterclaim. But does it apply, and is it appropriate for the court to grant or deny?
So I would like to know, does the Truth in Lending Act apply in this case?
Okay, how have they violated the Truth in Lending Act?
So I asked them, and they admitted that it does apply. And let me get my note.
But how have they violated it? I mean, the fact that it applies is one thing. If they violate it, that's another thing. How have they violated it? See, that's what I mean. You say things you hear or you read, but you don't know how they apply.
So basically, that's where I got these laws from when I started doing my research within the Truth in Lending Act, when I brought up the 12 CFR and the USCs or whatever. So basically, that's why I was bringing up with me extending my credit. Is that not make me the creditor?
But you didn't, sir. You didn't extend your credit. You borrowed, which makes you a debtor. There's no credit for you to extend. The bank had the credit. The bank had the money. Credit means you start out with something. If you're a creditor, if you have credit, it means you start out with something. If you borrow $5,000, you're starting out with nothing and you're asking somebody to give you $5,000. Creditor means you got the 5. Borrower means I'm asking. Debtor means I'm asking for the 5. So where's your credit, sir?
Okay, so 15 USC 1602.
No, sir, no.
That doesn't apply?
No.
So I'm just.
So you just looked up a bunch of stuff that doesn't apply.
So the contract is not the credit card.
It's a personal loan, sir. It's not a credit card. You went to a bank, you asked for a loan, they gave you a loan, they want their money back.
So are there any other genuine issues to discuss?
No, sir, none that I'm aware of. I'm going to grant judgment in the amount of $5,000 plus $266 in court costs to the plaintiffs. I'll get you an order, Mr. Pippin, if you or your or the other attorneys will prepare that order, or if you've already sent one in, we'll sign it.
I'm sorry, I didn't mean to interrupt.
And then also the counterclaim has been denied in full.
Your Honor, thank you. I will make sure the court gets an order. I don't know if my colleague has or not. And obviously cannot give opposing parties legal advice, but if a little bit of this effort, instead of future research, is spent reaching out to the firm, they'd be more than happy to work out some kind of payment arrangement and get this resolved so as to, have it beyond, in Mr. Whitney's past. So without giving advice, I think that would be a wise decision if it were me.
All righty. So at this time, the court has addressed each of the cases on the calendar. The court is adjourned. Mr. Whitney will go ahead and make sure you get a copy of the court's order, okay?
Okay.
All right. Thank you, sir.
Thank you for all your time today, Your Honor. I hope you have a good day. Good evening.
No problem.
Can I stay on for 1 second?
Sure. One second. Let me stop sharing.